that you've been you've been revising for LWD, you're actually lying. And I almost believed them because no one ever, I know, no one ever like per se revises for the unit. Like you wouldn't, like ideally you wouldn't set apart a day, and what you're doing is legal writing and drafting. Let me tell you the truth. I am just like you, okay? I never, even one time, yeah, uh, sat down and seriously revised for LWD the same way you would revise, let's say, for the 4Cs. Which 4Cs you've already, oh, you remain with one, so you don't take it as seriously as maybe your commercial or maybe your convincing, and maybe it's because of its simplicity. This particular unit is very easy. That's number one. Number two, it is very, very petty. Like petty. This is one of those units, if you miss a comma or you miss a full stop, the marker will be offended. Like one of the, like those rules, general rules that the marker is looking out for is your punctuation. Like those kidogo things that you think ideally wouldn't matter. Yes, those ones, okay? So this unit tomorrow, you're not going to write fast because, okay, well, you'll write fast, but you cannot afford not to punctuate, like missing out your commas, missing out your, your full stop, maybe misplacing your punctuations. So you have to make sure as you're writing fast, you're punctuating. You have the luxury of not punctuating in these other units. However, for LWD, you have to punctuate. Now, very quickly, because I know that you want to draft, but very quickly, I'll just do like an overview, a general overview, because even as you're drafting, there's a particular language that you ought to use, okay? So we could start with that, and then consequently, we start drafting. So we will do that in the next, today, I promise if I say it's 10 minutes, actually 10 minutes, okay? Because whether you have to go back and start cramming those formats if you want to cram, or you have to go back and, there's no time to draft, yeah? So the only time you have is to maybe try and, a bad advice, but it's the truth. So I'm going to project some material here. We look at it together, but I'll just like pitia quick fast because of time. And then we start drafting. Yeah. So just give me a minute. Let me get that material. We go straight together. And I believe you have. I have shared it so many times on the group. So of course you have it. Example, oh Lord. For example, if my network might buffer, if it buffers and you lose me, just let me know. Yeah. So because of the rains, I believe, not because it's bad network. So I'm telling you guys that there's some rules that you need to remember, like you keep in the back of your mind when you're drafting. Okay. So you need to remember, first and foremost, as you're drafting, you have to use active voice. It doesn't matter what you're writing. You have to remember to use active voice. Active voice is that voice. You start with SVO, yeah, subject, verb, and object in that manner. For example, you'd say the boy kicked the ball, and not the ball was kicked by the boy. So as you're drafting, remember to use active voice, okay? So I'm just going to remind you rules kidogo, and then we move on, Cindy. So I'm just, because it's, I know you know these, but I'm just going to remind you. So qualities of good writing, number one, you have to make choices as you're drafting, whatever you're drafting. Making a choice means you're not going to have something which you don't intend to have in your final document. For example, if you didn't intend to ask me for damages in your demand letter, then don't have it there. Number two, clarity. They say that clarity is the hallmark of good legal writing. Basically, it means you're using active voice, number one. Number two, you're omitting any verbosity. And number three, you're extremely, extremely clear, and you have to avoid legal jargons at all costs. Tomorrow, as you're drafting, don't say we are off. Don't start saying they're about, okay? You'll use those in your commercial and other units, but you cannot say they're about reasons. Therefore, such words, they're actually frowned upon in LWD. So you have to be very clear. Omit everything you don't need. In fact, I was telling you guys, I scored a 55 out of 60 in this unit. And not because I read, yeah, it's because I remembered to be very, very clear. As you're writing, write as if you're addressing a grade 2 toddler. Like, write like you're speaking to a child. Be very, very simple, deliberately simple. Okay. So you are going to use your very, very heavy vocabularies after your LWD, but you can never, never, ever use legal jargons or those heavy, heavy terms while you're writing. Okay. Equally logical structure. There's a topic for paragraphs. I'll make it very easy. It's a very easy topic. However, your logical structure means you're going to start with what you, for example, all these draftings that I'm going to project shortly, they have formats, okay? If it's a demand letter, you're going to start with the factual basis and then the law support paragraph and not the other way around, yeah? So logical structure means your story is flowy or your drafting is flowy from A to Z. Equally spelling, of course, I know that you might think it's very easy, yeah, at its spelling, you're wondering, see, that's obvious. However, let me tell you, I find myself writing, because writing with a pen is so hard. So if you're typing, you would easily know that there is a mistake because it will be underlined by your laptop. Otherwise, if you're writing with a pen, you're prone to actually making spelling errors. Yeah. So be very certain not to make spelling errors. Ask yourself, by the way, is this how we write this word? This is not how we write the word. If you're not sure about the spelling, just abandon it. Equally, your grammar, how you use the verbs, how you use your tense, how you use your adverbs, they have to be in the correct place. Like you have to be very, you remember how you used to write your compositions like that, yeah? So your grammar, like short sentences, very clear and precise and well punctuated, including your adverbs. And adverbs reminds me, you remember when Senior was saying when a verb comes before a noun and a proverb comes before an adverb. Otherwise, your verbs have to be in the correct place. Your punctuation, do not forget to punctuate. By the way, after you write, make sure you proofread and ask yourself, have I punctuated correctly? Yeah. Equally precision, being precise. The question usually is how do you become precise in your work? Equally, you can't afford any ambiguity. You have to be very concise, but as you're being concise, you have to be complete, because there is danger of being extremely brief and then you're not communicating. Like now you're struggling to be very, very precise, but now you're missing the whole point because your preciseness is not complete. Like your sentences are hanging, okay? So we are not getting the message, okay? Equally, your writing has to have elegance. Well, elegance comes with a lot of practice. An elegant piece is a piece that you read and then you start smiling. You don't have to finish reading it, yeah. But elegance will come with a lot of practice, and you can now effortlessly write elegantly. And then short sentences, of course, use short sentences. Of course, we do not have like a standard average sentence length, but it is advisable to keep your sentence length below 25 words. If your sentence length is above 25 words, you might actually, number one, you'll lose the reader. The reader will get tired. Yeah. So they are reading a lengthy sentence so that they get tired, very exhausted. They're not able, you don't communicate. That's the import of having very lengthy sentences, because lengthy sentences will strain the memory of the reader. Equally, the reader will lose you. And you might actually distort the logical order if you use overly lengthy sentences. Majorly, if you're reading a very long sentence, you get tired in the middle of the sentence, you've already forgotten what was the first two words because it's very lengthy. Equally, as you're writing, remember to use plain English. Of course, I know that you know what plain English is, but a question would be, what's the difference between plain English and plain language? So you could look into that. What's the distinction between plain English and plain language? Anyway, nonetheless, if you're writing, avoid legal language at all. Avoid technical terms, foreign words, those Latin terms. Yeah, those ones you'll leave outside the door, the exam room. You'll collect them as you leave. Otherwise, not technical. Be simple. Like that's how to impress a legal writing and drafting marker. Being extremely simple. Okay. So I wanted to remind you those very simple rules. And then we start drafting now. Of course, I want us to draft because majorly this unit is drafting. So I'm going to share with you guys. You have these notes. I've sent them 1 million times, but I'll share them again. We are going to draft, and then towards the end, when you guys start muting me, we can do the theory bit, because that's not as much, as long as we understand drafting. So let me check a list that I have prepared for you guys for purposes of drafting. Actually, we prepared the list with you a few weeks ago. I'm not sure whether you remember the list. Yeah. So this is the list. It has 16 documents. Imagine. Well, not a lot, because these documents they have formats. So that is what makes them easy, because they have format. Ideally, if you know the format, you can draft anything, because the fact will be different. But if you know the format, you can draft anything. So the first document is a demand letter, okay? And the second document is a response to a demand letter. A response to demand letter, actually, demand letter and response to demand letter was March question 1. Okay, like this year question 1 was drafting a demand letter and a response to a demand letter. And then number 3, a legal opinion. Number 4, there is an office memo. Number 5, a statutory declaration. And then an affidavit, a deed poll, a power of attorney, a case brief, contracts, bills, amendment bills, regulations, policies, legislative instructions, or what you could call drafting instructions. And then lastly, we have cabinet memorandum. So let's start with the first one. So I'm going to check a copy of a demand letter, and then we'll use. By the way, we can't take more than 10 minutes on each of those documents. Si unaona vile there are so many, yeah. So it's kidogo time. I'll just give you the format of the document, what you need to remember as tukisonga, because we can't afford to use a lot of time. Someone's video is on. I'm not sure whether they know, but check whether your camera is on. Okay, so let's start with a demand letter. This is how a demand letter looks like. Tomorrow, you'll do a letterhead, because you'll do a letter. There will be a letter there, not necessarily a demand letter. Oh, someone was asking whether a demand letter is a client care. No, it is not. Okay, so a demand letter is for purposes of making a demand. When a client comes to your chambers for the very first time, you will send out a demand letter, because if you go to court and file a suit without first of all having sent a demand letter, it is a ground for denying you costs. Okay, so the first document you're going to send out is a demand letter. A demand letter, you do not have time for logos. Yeah, you only have time for the very basic content of a letterhead. So what I have highlighted is the letterhead of the sender, or rather the address and the name of the sender. Yeah, that is what goes into the topmost part of your letter. But don't usianze kuchora letterheads, logo, wataka kuchora for magistrate. So just leave that. Don't do it. So it's okay. Let me just show you. It would be, oh Lord, I've distorted it. Oh my God. Oh Lord, I just retired it, but just assume the way it is, but without this, okay? So no logos. Now you could write the name of the law firm. Of course, it's a law firm sending out the letter, and then you write your physical address, your email, and that's it. And then the easiest way to do a simple letterhead is by drafting, after you write the address of the sender, just slightly below that, you draw a straight line. So tomorrow carry a ruler. Yeah, kama you have a straight hand, ni sawa. Otherwise, you just draw, after you write the name of the sender, the address of the sender rather, you draw like a very straight line, makes your work very neat, because now you're able to separate your letterhead from the rest of your document. Okay, and then you will go to your the obvious content of a letter, our ref, your ref, and the date. Our ref is basically the reference number of that file at the law firm. You could put just put anything. And then your ref is to be advised, because this is the time this is the first time you're writing to Chief Executive Aga Khan University Hospital, and the date as well. The date has to be there. So you could write tomorrow's date, or if you're given a date, then you could use that date. But I would like to think the date wouldn't be there. So you will write tomorrow's date, the date that you're sitting for the paper. And then after our ref, your ref, and the date, you proceed and write the name of the recipient. If you're sending the letter to an organization or a corporate or a body, yeah, you're not sending to a natural person. You cannot address, let's say, Lord, Aga Khan University Hospital, you cannot address the letter to Aga Khan University Hospital. Like, Aga Khan University Hospital is like an entire organization. So your letter has to be addressed to a particular person. For example, the Chief Executive Officer, Aga Khan University Hospital, or maybe the CEO, Kenya School of Law. So your letter has to go to a particular person, okay? So you write the address of the recipient over there. So you will say, let's say, Chief Executive Officer, Aga Khan University Hospital, the postal address, it will be there in the exam, and then the telephone number, the email. If these details are not there in the paper, just write anything. You can write PO Box 52 Nairobi. That's okay. As long as you show that you understand that the details of your recipient, you have to include the postal address. And then, of course, the salutation here, you would say, dear sir or madam, where the person you're sending the letter to is unknown to you. But assuming you know that their name is Miss, let's say, Mrs. Monica, then you will say, dear Mrs. Monica. But when they are unknown to you, dear sir or madam, okay? And then you go to your re. Your re has to be very, 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 very concise, extremely concise. And the easiest way of drafting a re for a demand letter or for any, okay, for a demand letter, you would say, if you're getting confused, you'll say demand for. That's the easiest way of drafting your re for demand letter. You'll say demand for. And of course, now, what are you demanding for? Maybe demand for admission of liability, for medical negligence, or you just say demand for. So every single time you write demand for, everything else will just come to you effortlessly. Okay, so if you can't get a re for your demand letter, just start with the words demand for. Okay, otherwise it's not mandatory for you to start with demand for. It's just a simpler way of enabling you to remember. So if you can't remember how to maybe come up with another re, just say demand for, everything else will just come to you. So for example, here the re was medical negligence by your doctor against Miss Alice Mora. So it's allowable for you to count your re like that, as long as it is concise and complete. If you read a re, is basically will capture your letter in entirety, exactly what you want to communicate, very, very, very concisely. So I don't even have to read the content. If I see your letter, the re, I'm able to know what consequently you're talking about. Okay. Anyway, so consequently, after you count your re, remember it has to be a very short re, but complete. Go to your introductory paragraph, this paragraph over here. Yeah. And this particular paragraph is for purposes of illustrative. Where did you get your instructions from? Like, who instructed you? Yeah. Why are you writing to us? So in this particular letter, you will say, or any other letter for that purpose, we act on behalf of our client, Alice Mora, who's instructed us to address you as follows. Do not make the mistake of saying, who's instructed us to address you as Yaranda. You know, you see letters written here, Randa, here, herein below. Do not do that. It is address you as follows, or any other simple language. Do not say here, Randa, herein below. Okay. So after your introductory paragraph, basically telling us who sent you to write to us, or who are you acting for, or under whose authority are you writing, you proceed to your factual basis paragraph. So the factual basis paragraph is where you're telling a story, like what happened. For example, in this instance, you like very, very precisely. The facts might be a lot. Okay, they won't be a lot for LWD, but if they are a lot, then you have to make sure you're picking out the facts that are really, really, really important for your purposes. Don't write all the facts there, and do not copy paste those facts word for word. Let's say the question says there is one here for these guys who are sitting the match paper. So you can say, there's a question here. Yeah? The first sentence is, you sired the above named child with utanijua vizuri. Yeah, that's the first sentence. So you cannot copy paste that sentence the way it is, you know? So you paraphrase, because you have to show some aspects of applying yourself, all right? So you paraphrase the sentence, and whatever is in that paper, don't copy paste word for word. That's what I'm trying to say. So I cannot tell you really how to write your factual basis. As long as you remember, it's telling a very coherent story. Remember the rules of good legal writing, and remember to use plain language, and do not copy paste the facts the way they are. Just paraphrase them. Okay. So after telling your story, ideally your factual basis story in an exam could take one paragraph. However, while you have so many facts and you have to break your paragraph, then don't have an extremely lengthy paragraph. For example, assuming that you had a paragraph looking like this, you know, honestly, it actually kwanza inakaa vibaya, si ndio? Like it looks really, really, it's not appealing. And remember, we say that you have to, as you're writing, you have to have some elegance. So paragraph can be this lengthy. So where you have so many facts, you can have them in at least 2 paragraphs at most. Don't overdo it. Now you have 13 paragraphs on factual basis. So if you need to have a lot of facts, it's 2 paragraphs maximum. After your factual basis, just telling us what happened. For example, there is someone who went to a hospital, they took a, okay, for example, you will be referring to your client, you will be saying our client. That on 1st June 2016, our client consulted Harrison Sewe, an employed gyna at your hospital, yeah, on an appropriate contraceptive method. And then, you know, their doctor advised them that an implanon is the best. However, now our client is pregnant. And of course, this particular doctor of yours is now negligently negligent for breach of their duty of care. They misled our client. Anyway, so after setting out your factual basis, you go to your law support paragraph or your legal basis paragraph. So your legal basis paragraph is the paragraph that shows the relation between the law and your fact. So that paragraph, you would endeavor to marry the law and the fact. So for example, over here, you will tell us that your doctor, so this is where our legal basis paragraph begins. We will tell them that your doctor owed a duty of care to our client to provide medical services with reasonable skills. And you know, they failed because now they promised our client she wouldn't be pregnant after they get the implanon procedure. So our client is now pregnant, you know, so you set out that particular aspect in regards to our fact. So you're just trying to marry seamlessly the law and the fact. And then after marrying the law and the fact in your legal basis paragraph, make sure to maybe mention the constitution here and there. You could say, you know, your doctor is actually has the right, yeah, to provide the highest standard of health, yeah, to any person who comes to them pursuant to Article 43. So you could mention some provisos of the law if you can remember. If you can remember generally, hey, you know, this we found under the Land Act, we can find this in the Companies Act. You can generally mention that this particular proviso is to be found in the Companies Act. So your legal support paragraph, you have to refer to some law because the only basis that you have for demanding from someone is because you have a legal right that has been breached. Well, the law could be found in the Constitution, in the statute, in the common law. You could equally use a case to support your demand. And then after your legal basis paragraph, you proceed to your conclusion. Okay, so it's basically an introduction, factual basis, legal basis, and then ultimately your conclusion. So your conclusion includes the following. Number 1, you make a demand. For example, you'd say our instructions are therefore to demand that your client admits liability and then pay damages suffered by our client because of unplanned pregnancy. Yes, please go on. Is someone unmuted? Okay, so guys, I hope I'm not muted. I am not muted. So you write your demand in your conclusion. You will have the demand first of all, like what do you want from your recipient, the recipient of your letter, and then after telling them what you want from them, you proceed and give them time limit. Like you'll tell them this is our demand that you admit liability, and then you have 7 days from the date of receipt to actually respond to this particular letter admitting liability. And then if you don't happen, so 3 things: make your demand, give them time within which to comply. Lastly, give them ultimatum, consequences of non-compliance. Okay, so those are the 3 things that you will have in your conclusion: make a demand, give them time within which to comply, and lastly, tell them the consequences of compliance. So if you don't comply, we are going to institute legal proceedings against you. And then lastly, you sign off your letter. You will say you was faithfully Subira Karue, managing partner for Farm B7 Advocates LLP. You can see your client as well, because of course the client, remember, you have a duty to communicate. Yeah, Ama, you forgot after your professional ethics and trial. So you have a duty to communicate. You can CC the client because you want the client to keep the client in the loop regarding what you're doing. So that's how you do a demand letter. I'm not sure that we have any questions re a demand letter because we are unable to I can't tell you we draft together because of time. The most I can do is tell you the content in each paragraph. Okay, sawa. So the second document on our list is a response to a demand letter. By the way, I can't see your hands because I'm on the side of the screen. So if you have a question, you just do what you do. There are no rules here. So you just raise up your hand and then you could say, you know what, I have a question. Okay, so let me get a response to a demand letter. We go through a response to a demand letter. I have a response to a demand letter which is proper for your purposes. So we could
Lydia.
So let me just
Lydia.
get oh, there's a hand up. Oh my God, it's down. Please go on. I didn't see who they were because they put the hand down too fast.
Can you hear us?
Oh, I can hear you now. I can hear you now. Please go on. I can hear you.
Someone who was called. There was someone who was trying to say something.
Oh my God, I can imagine.
But I think it's about admitting people.
Oh, I can't see anyone in the lobby. Can you guys see anyone in the lobby? Because I can't. We don't have that red mark showing there is someone on the lobby, but I think they're here now. Ama, I believe they're here. Okay, sawa.
Lydia, a question.
Yes.
A question.
Yes, please. Yes, please.
As we underline the re part, do we underline up to the RE part or just after the colon?
Well, actually, you can do it. You see the letter I'm projecting right now. You can do it in any way. There are no rules. There are no fast and for me, this is how I do it. I would underline my re. I would underline everything. I wouldn't underline the word re, but it's not injurious if you underline the re as well. It's okay. But of course, now if you decide to underline the re, you have to like push your the other words towards the re. But there are no rules. You just pick whatever you think is elegant for your purposes. But there are no hard and fast rules on whether you're underlining everything. You won't miss a mark if you underline or you fail to underline. But you can do either. It's okay. Either is allowable. Yeah. Okay, so this
thank you.
You're welcome. This is a response to a demand letter. And of course, we're not going to belabor all the letterhead. So we start with the, oh, Lord, no. This is not, this is not the one I'm looking for. Oh, Lord, so sorry. That's not the one that I'm looking for. There is another one that I'm looking for. Oh, Lord, I think I'll have to project this other one. But I wanted a particular one nonetheless. This will serve the purpose. Okay, so let me project a response to a demand letter. Oh, we are taking 10 minutes for each, but then we are following the rules. So if 7 this 709, so 720 prompt, we should be done with this. Actually, this is kidogo 7:15, 16. So this is a response to a demand letter. Of course, you will start with the caption over there. I mean the letterhead, sorry, and then you'll read the date, and then the address of your recipient. You write the address of your recipient, and then we know it's a madam. If you don't know it's a madam, you could say, dear sir or madam, because you have to be very gender neutral. Oh, by the way, before I forget, one of the question is, why do you need to be gender neutral, or why and how do you achieve gender, or rather, how would you make sure you're gender neutral in your writing? Someone is unmuted. So if you don't know whether your recipient is a sir or a madam, you could say sir or madam. Or if you know their gender, you can just write the gender there, dear sir, dear madam. If you know the name, you could say dear Miss AXYZ, says dear Mr. whoever. Okay, and then your re for responses. Oh Lord, let me just mute all of you, but you can unmute. There was someone who was unmuted, and I couldn't see who. Okay, so your response, you will start with your re will you see in your re you just couch it. These are very lengthy re. Don't write like this. Yeah, it's very lengthy. Yeah, so your re will be precise, and then you will just couch it as you couched you can copy paste whatever is on the demand letter, because this is a response to the demand letter. So you can copy paste the re as it is in the demand letter, or you could just paraphrase your own re. For example, if the demand letter says demand for medical negligence, you could say demand for alleged medical negligence if you're not admitting. Yeah. Otherwise, the simplest thing you can do, copy paste the re as it is in the demand letter, and then you proceed your introductory paragraph, who's instructed you, who are you, where you're coming from, and who's instructed you, and then you proceed to respond. As you're responding, you'll either be saying whether your client admits or whether they are denying the content of your letter. You can tell your own version of the story. For example, in this particular case, the version that had been given in the demand letter was inaccurate. So there was need to restate the facts as they are, as you've been told by your client. So it was necessary for us to tell this particular sender of the demand letter that, you know what, this is not the position. The position is this, you know. So, for example, here you could tell them, you know, your client sent an email correspondence to our client informing them that the offer sample for the coffee that had been submitted was actually in tandem with the required quality. And therefore, they were asked to bring some green coffee beans, and it was going to be collected at Bolloré Transport and Logistics by your client. So you tell that version of the story if what your client is telling you is entirely different from what has been told in the demand letter. So you can tell you, basically, really, again, no rules regarding how you respond to a demand letter. Depends with what your client has told you. If they've told you they're admitting, then you respond and you admit. You say, yeah, our client is very, 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 very amenable to settling this particular amount in the following terms. So you respond to a demand letter depending on what your client has told you. If they tell you they're not admitting, you respond denying liability. If they've told you they are ready to pay, you respond saying we are ready to pay. So it depends with what you've been told by your client. More often than not, in an exam setup, the client will be denying. So you will write that our client informs us that this is not the position. Maybe they had already you know, they've already complied with all their obligations as per the agreement, and therefore they believe they have nothing else to do. So proceed and sue. Okay, don't say proceed and sue. So you would say, you tell the story, and then ultimately you say premise on the foregoing, the conclusion paragraph. Our client will not make good any of your unfounded demands. Kindly advise yours accordingly. Additionally, our client does not have privity of contract with Moyer. In suit, our client reserves the right to sue yours for maliciously tainting it as dishonest, deceitful, mendacious, untruthful, and skullduggery in its conduct of. So you, and then you sign off. So I cannot tell you for sure how you respond to a demand letter tomorrow, but you just tell the factual basis as told by your client. You don't need, you can allude to the law if what has been told. Basically, you're just either telling them that you are agreeable to what they are saying, or you're just disregarding what they are saying in your response. Okay, so if you're responding, remember you have to have an introductory paragraph, and then your response as told by your client, and then the conclusion, and then you sign off the letter. So your conclusion is whether we are going now to make good your demand, or whether we are disregarding your demand entirely, or maybe we are admitting part of your demand and denying the rest of it. Yeah. So a response, I don't even know what to tell you. It will depend with what is in the facts. Okay, but it will be easy. Doing a response is very easy, but I think it won't be in your exam. So that you know. Okay, so the next thing is a legal opinion. So I'm looking at that list, and then I'm checking those documents as we move. So let me get a legal opinion. Okay, do you have a question on responding to demand letters? As I get a legal opinion, I think
Can
we
you
should
check the chat, Lydia? I think people are talking about that there's a lot of legalese in the letter.
Oh, yeah, true, accurate, because I was looking for a simpler one, which I didn't find. You know, it has a lot of legalese. I agree with you. Absolutely. I'm not even going to share it with you. I just wanted to show you the format that it will take. You know, out here, you get brainwashed immediately after Kenya School of Law. But yeah, it has a lot of legalese. You would avoid those kabisa, like out of the window. Yeah. So that is a bad letter in terms of rules of plain English, but it has the content. I just wanted to show you how you will set out your. I'll get the simpler one. I don't want to touch my phone. But it's on my phone. So I'm going to share the simpler one for purposes of the exam with you, like one that follows the rules. I am so sorry for trying to, for showing you legalese. I don't want to, I want your mind to be like very, very, like fresh, simple English. So please forgive me. Okay. So let me project a legal opinion. So I'm telling you guys, a legal opinion, I highly think it will be oh, someone has asked a question. Do the words demand letter have to appear in the letter? No, they do not. I was telling you, you can use them where you're struggling to come up with a re. So if you're struggling to come up with a re, because it happens, yeah, you have a mind block, you're trying to think, hey, what will be my re? You can always say demand for. If you say demand for, your re will be easy, like you would easily know what to write consequently in your sentence, in your re. Okay, so I believe that a legal opinion might be question one. So a legal opinion has a letterhead. Just adopt the letterhead I had shown you earlier. Hizi story achana nazo. You know, this has color, it has a logo. You don't have time, or even you can only do this, I think, with a laptop. Yeah. So tomorrow, just adopt that particular simple letterhead that we said. Draw a line and then write the name of the law firm, the postal address, the email, and the phone number. That's it. Okay. And then you go to your re and the date. You can have them on one. You can do it like this, but if you have them on one continuous sentence, I think it looks better. Really up to you again. Depends on what you prefer. So our re, your re, and the dates. Yeah, I mean our ref, your ref, and the date. And then we are addressing it. So this is a legal opinion that was being done in response to the demand letter sent by Aga Khan Hospital, sent to Aga Khan Hospital. So this particular legal opinion is done in response to that particular, or rather advising Aga Khan Hospital not to do, because their doctor now was medically negligent, or maybe allegedly, yeah, they were negligent while they were treating a patient. Anyway, nonetheless, it has the name of the recipient. So a legal opinion is a form of advice to your client. And legal opinions, there are two modes in which you can render advisory. Okay, there is number one, a legal opinion, and number two, an office memorandum. So there are those two ways of rendering advice, or maybe putting your advice down on paper. So you can either do a legal opinion or you can do an office memo. And a legal opinion is usually done where you're advising your own client, like it's your client. An office memo is done where you're in the same law firm, and maybe let's say your pupil master asks you to do, they want an advice on a particular file. So you will do an office memo. An office memo is equally a way of giving advice. Okay, so this is the first one, legal opinion. Legal opinion, majorly you send legal opinions to clients or anyone who's not in your law firm, but they want some sort of advice from you. Okay, it is really contained in a legal opinion. So a legal opinion, after your the name of your recipient, you go to your salutation, dear sir, madam. If we don't know whether the CEO Aga Khan is a sir or a madam, then you have to be very gender neutral, gender sensitive. You can't just say dear sir. It has to be dear sir or madam. And then you go to your re. Okay, so your re, of course, again, you really don't have to say legal opinion on. But you see, if you say legal opinion on, ideally everything else just comes to you. So the easiest way of couching a re in a legal opinion, or even a demand letter, is saying demand for, or saying legal opinion on. Actually, it's the most pragmatic approach. If you say legal, by the way, whatever the question is, just start by writing legal opinion on. You'll know exactly what comes next. Yeah. Otherwise, you might start grappling with what goes into my re. So just write legal opinion on. However, again, it could be any other re that connotes you're giving advice, or this is your advice on a particular set of facts as might have been requested by your client. Okay, so after your you go to our the here is legal opinion on claim for medical negligence against Alice Mora. By then tomorrow you have to carry a ruler, because if you don't underline this, it will look very funny. It looks weird, right? It is not elegant. So you carry a ruler for purposes of being elegant. So you would have your reader, and then immediately after your read, you go to what we've been calling our introductory paragraph. So we'll be saying we make reference to the above matter, and further to the demand letter, and wish to render a legal opinion as follows. Don't say as I know the temptation of saying as hereunder, herein below, herein after. So you say as follows. Okay. Now, this particular introductory paragraph, of course, depends with where you're coming from with your client. It might actually, you might say we refer to the above matter and our meeting on 17th of July 2023, whereby you requested us to render our legal opinion, which we now render. Okay, don't say that, better word. But it could be you had a meeting, your client requested you to render a legal opinion, and that's where you're coming from. That's why you're sending it. So you look at, did you get a request from your client? Yeah. Or did you have a meeting, or did they call you and ask you to render a legal opinion? Because it's a billable document, so you cannot draft it without instructions. And then after your introductory paragraph, you use FIRAC. So for legal opinions, you're using FIRAC. Okay, FIRAC. So the first paragraph will be your factual basis. For a legal opinion, it is highly, highly advisable. This legal opinion, have you guys been taught by Miss Kungu? Oh Lord, I really, really hope you have, or maybe you have met her, yeah, even during your orals. So Miss Kungu taught me legal writing. And this demand letter, legal opinion, she said it was a very, very good legal opinion. I've never lost it up to this day. Yeah, because it was a really, really good legal opinion in her words. So you will start with factual basis. That's the first bit of your legal opinion. And factual basis is basically your background. The facts are like a story. You know, on 4th of June, Alice Mora came to your hospital. Yeah, your family planning clinic to get a contraceptive method. They were told they wouldn't be able to conceive for the next 3 years, but now she's pregnant. Okay. So you tell us where you restate the facts to your client. Don't assume the client knows the facts. So you restate them. You tell them this is what we have picked from the letter or from our several meetings that we've had. So after your factual background, and you see you have subheadings, so factual context or factual background, or you could say background. And then you go to part B of your legal opinion. Part B would be issues for consideration, because as in FIRAC, the second limb is issues for consideration. For your issues, usually issues will come from the facts. Like you will pick your issues from the facts, not from the from a vacuum. By oh Lord, we 10 minutes. No, 30. Let's finish at 30. 7 to 7:24, so 7:30. We start drafting a bill. So issues for consideration, you tell them whether your doctor, you just tell them what the issues are. It's up to you to pick the issues. Don't write more than 2 issues. Don't make a mistake of writing 5 issues or so many. So your issues for consideration will be less than 2. Do not write, if you have to actually write more than 2, 3 maximum. If you really, really have to, 3 maximum. Because after, I'll show you shortly what will happen to you if you have many issues. After your issues in our rule of law are, we go to our rule of law. So in your rule of law, do not explain anything. So you would say, for example, in our analysis of the above issues, reliance is placed on the following applicable laws. And then you set out the laws. A, Constitution of Kenya. B, treaty and legislations. You tell us you are relying on the following treaty. There is this treaty for elimination of discrimination against women, Evidence Act, Health Act. And then you tell us cases, whether you have any. Highly likely, you don't have any cases. Okay, my thinking, because it might be an area of the law you're unfamiliar with, for example, data protection. If you have a case, Misawa, you could put a case there. But if you don't have a case, don't force it. Yeah, just leave it like that without a case. It's okay. It won't do you any harm. Okay. So after your rule of law, as you guys can see, you're not explaining anything. You're just telling us generally we will rely on the Constitution. However, you know, Constitution is a very big document. If you remember some articles, you could tell us maybe article Article 40. You could mention briefly articles, whatever articles you're relying upon. But if you don't remember, it's still okay, because consequently you're going to analyze the applicable articles in the next part of your legal opinion. So after setting out your issues, you go to your analysis of the issues. In your analysis of the issues, you're going to copy paste all your issues, like the 3 issues that you have. You're going to, of course, you can't copy paste, like you're going to write them again in your analysis. For example, over here, you will copy paste like all the 3 issues, all of them, the 3 issues. We have the first issue, the second issue, the third issue. So you will copy paste your issues, and then you analyze each of the issue independently. That is why I was telling you, if you have 5 issues, you're going to analyze 5 issues. So it's actually in your best interest, if you limit yourself to kidogo issues, don't have a lot of issues, you know. So analysis of the issues, you start with issue number 1. Our issue number 1 was whether the doctor was negligent. In analyzing the issue, as you had stated in the demand letter, this is actually the backbone of a legal opinion. You will be telling our client that, you know, this is what medical negligence means, yeah? And you can use maybe Don Hawk versus Stevenson, telling them that, you know what, these are the 3-tier test for negligence. To be proven, you have to establish the following elements. So you set out those. So well, really, you see, if you know, the rule is to tell us the law applicable briefly, and now tell us in this context, do you think our doctor was negligent? Because that is ultimately what you're going to tell the hospital. Yeah. So you tell them medical negligence arises in the following circumstances. And generally, you know, we have a 3-tier test. There has to be a duty of care, there has to be a breach, and consequently, a party must have suffered harm or damage because of such breach of a duty of care. So you tell them briefly now, our doctor owes a duty of care to patients generally. And the duty of care will arise when you go to a doctor and they agree to diagnose you, and they actually tell you they understand, okay, don't I know you're seeing some footnotes here. Don't put footnotes. How will you even put footnotes in your handwriting? So you write, you can have some cases supporting this issue. And then lastly, so after telling us the law that is applicable, and of course, in the light of the facts, you're not trying to analyze that law independently. It is like marrying the law and the facts. You're analyzing the law as it is applicable to your factual basis. Okay. So after analyzing the law and telling us how they marry and merge the facts, you lastly proceed and conclude. So every single issue, it has the factual basis, very brief factual basis, the law applicable to those facts, and lastly, a conclusion. So every issue in your analysis, those 3 parts are very brief. Some brief facts, for example, doctors generally owe duty of care to their patients. Medical negligence is defined as follows. In this particular set of facts, Alice visited a doctor. The doctor promised they are able to actually help. And now Alice has suffered damage because of that particular negligence by your doctor. So you conclude your paragraph. Your conclusion is telling the hospital, because the hospital wants to know, is our doctor negligent or not? So telling them that in this particular case, the doctor was supposed to give Alice the best care, the best standard of care. And remember to punctuate short sentences. He was supposed to act within reasonable standards expected of a professional doctor in rendering an opinion to Alice. And as discussed above, the doctor did not exercise ordinary care when treating Alice on the best method of protecting her from conceiving. Moreover, as further tests conducted by your institution revealed that Implanon had not been implanted. And then you can tell them, in this premise, the doctor might be negligent. Yeah, on that premise. So you conclude your issue. You go to issue number 2, you do the same thing. Whether the hospital is vicariously liable for the actions of the doctor, you analyze that issue. So you start by telling us what is vicarious liability, number 1. And number 2, in this particular set of facts, are we vicariously liable depending on what you've told us vicarious liability is? And then you conclude. So that is what you're doing for each paragraph. You tell us briefly the law, briefly how they relate to our facts, and lastly, the conclusion. So the conclusion is the doctor is therefore an employee and therefore, because of the existence of the employee-employer relationship, then you might be vicariously liable for the negligence of your doctor. And then lastly, you go to your issue number 3, you do the same. You do the same facts, kidogo, the law, and then you conclude by telling us, what do you think? Yeah, do you think this guy might, for example, here, therefore, if the doctor is negligent, will be liable to compensate Alice. So you tell us every issue, the law applicable to that issue, some facts that are related to that law, and lastly, you conclude by telling us, answering the issue. So you have to give us an answer to the issue, a yes or no. And then lastly, you conclude your legal opinion. Conclusion is basically conclusion. So you're telling the client now what's the way forward, because you've told us that our doctor was negligent, number 1, and number 2, you've told us that will be vicariously liable, and lastly, you've told us if Alice goes to court, then we're supposed to compensate her. What do we do? So that is what you're a baby is crying. You know, babies don't know that growing up is a scam. So your conclusion, you're telling us basically what's the way forward. So you start by telling us, you know, from our analysis, we're of the opinion that Alice has a valid cause of action against your gynecologist, and therefore, this is what you could do. Yeah, these are the possible options you could actually explore. Number 1, an out-of-court settlement. And then you tell them briefly what is an out-of-court settlement. You will say an out-of-court settlement involves the following. It could be mediation, could be arbitration, could be conciliation, could be negotiation. Yeah. Number 2, mitigate damages in case of litigation. So you can tell them to wait. Yeah, wait. When you're taken to court, you can try, if you are unable to dissuade Alice from going to court and then they ultimately go to court, you can try and mitigate damages in that litigation. You can use some defenses. You can get a few defenses to defend yourself, try to mitigate damages payable to Alice in court in case they go to court. So you give the client the options available in your conclusion, because the reason why you're writing to them, or the reason why they asked you to write to them, is because they need to know what to do. So a legal opinion has to convey some advice. What do we do now? What's the way forward? Yeah, so you will tell them you can try out a court settlement, you can mitigate. There are so many other solutions. Well, solution. You know, this is like an automatic solution to any problem. They can try an out-of-court settlement. They can try to indulge ADR, and they can mitigate damages in case they're taken to court. Yeah, and then after you tell the client that, you give them the most suitable options. You know, you've given them 2 options. Tell them which is the most suitable option. You can tell them, in our opinion, an out-of-court settlement will be the most suitable option because it is speedier, it is less expensive, and of course, it doesn't have an effect on relationship between the parties. Like, it doesn't distort relationships. So your relationship was still, Alice might still come back to your hospital. Yeah, if you try and negotiate and maybe settle out of court. And then lastly, you tell your client to trust that this opinion is sufficient for your purposes. And if you require any information, please do not hesitate to contact us. And then you sign off your letter. Yours faithfully, Victoria Makoha, for A&V Advocate LLP. That is ideally how you will do a legal opinion. You use FIRAC. Remember, the contents are an introductory paragraph, and then you go to your factual basis, where you tell a very brief story, and then you go to your issues. Don't have more than 2 issues. Otherwise, you'll have problems when analyzing. And then you go to your rule of law. Just state the law that is applicable very generally. If you don't remember specific law, just say Constitution of Kenya. Don't leave it like without anything. And then you go to your analysis. You're going to analyze each issue that you identified. You give us facts, to give us the law applicable in regards to that issue. And then lastly, conclude by giving your client options and tell them the most suitable option. And then you can ask them to reach out to you if they have any further clarifications. I want us to discuss a bill now. We discuss a bill and amendment of a bill. Okay, so let me check a bill. I'm not sure whether you have any questions regarding legal opinion, but legal opinion is basically easy. See, you've seen, it's easy. So let's discuss a bill. Just a minute, let me get a bill. Please go on. Yes, please. Hey, I can't hear you. Yes.
Can you hear me?
I can hear you now.
Yes, I had a question. You know, you had shown us the
Yes,
letterhead.
I had.
That one that you had shown us, the simple one. I wanted
Yes.
to take one last look.
Okay. Yeah, definitely. Definitely. Let me get it for you. The simple one. You just draw a line, but it has a logo. Ignore the logo. Let me project it. It has a logo over there. I'm trying to remove it, but now the document it distorts the document. I'm not sure. Oh, yeah, I think it's okay now. Oh Lord. Okay, there, it would something like that, but it has to be like centered, maybe like that. Oh Lord, you get the point. You can center it because it has left too much space up on Mele. Okay, so
Yes.
we discuss. Yeah, we
And my
discuss.
question is,
Yes, yes.
when we are drafting our legal opinion,
Mm-hmm.
will we always have a letterhead when we are doing
Yes,
LWD?
yes. It has to have not a letterhead per se, the
It's a
address of the
mark.
recipient, the address of the recipient, because you can you remember you can adopt any mode unless there is an address. As long as there is an address of the recipient, it's okay. You don't have to do it like this.
Okay.
You can put the address of the recipient anywhere. There are so many formats of letters. As long as the address of the address of the sender, sorry, is there. So no, you don't have to have a letterhead. Okay, sawa. So I get a bill now.
Lydia, sorry.
Yeah, please go on, no problem.
Just a quick question. Just before we get into drafting the bill, are we going to go through the memo since it's just basically the same? Is it the same format?
Well, a memo is not the same format. I wanted us to discuss one legislative drafting and then we come back to one other thing.
Yes, perfect.
Yeah, we'll discuss an office memo. It's not the same thing. The format is different. Okay, so let me project an office memo as I try to check my bill. An office memo will take the format of okay, this is how it will look like. Let me just show you an office memo. The title will be office memo, but basically it's you're advising someone within the law firm, like someone you work with. For example, let's say the title will be office memo. You could write office memo as you really don't need it, or well, you might need it. So you could have office memo. Makes sense. It looks funny without the title. So office memo, and then you write to who are you sending the office memo to? Yeah, so it will have, let's say your senior is called Mr. Kimani. Yeah, so you could call them Mr. Kimani, or the Swali refers to them. The question will tell you their name, and then from of course is your name. Let's say Lydia, and then the date that you're sending the office memo. Let's say tomorrow, 23rd of November 2023, and then the is what you've been told to do. They might have asked you to advise on legal alternatives available to someone. So your will be, wait, was this your project work question? I'm not sure whether it was you guys, but maybe you or the match cohort. So it will be legal alternatives available to Dr. Rutherford or whatever you've been told. Yeah, like, the real will be you're advising, but not advice per se. You're just rendering your opinion regarding a particular matter upon request by someone in your firm, usually maybe in another department, or maybe your senior, or maybe the managing partner. So an office memo is basically a form of an advice, but now it's within the same law firm. You're not sending out to a client. Okay, so you will say the first part of your office memo is usually the question presented. That's the first part. The question presented, very briefly, you reiterate what you are told to do. So you will say whether Dr. Rutherford has legal alternatives. That's the question. Or you can say the question presented was whether, or rather, the question I intend to answer is whether Dr. Rutherford has any legal alternatives. And then after the question presented, go to your brief answer. Yes, please. Yes, please. Someone is unmuted. Okay, you go to your brief answer. Your brief answer is an answer to the question presented. So you will either say yes or no. There's some explanatory notes I've sent explaining to you what exactly goes into your brief answer. So a brief answer at length. So a brief answer is yes or no, or maybe probably, or maybe. So you say the brief answer to the question presented is in the affirmative, okay? Or you say yes. Brief answer is yes, it is the duty of every employer to provide safe working conditions to his or her employees. And then you go to statement of fact. So that's how you will do an office memo. And by the way, I am really not sure whether it was you guys. Was it you? I'm not sure. You know, this particular legal opinion, you see, I mean, office memo is in accordance with the course outline, because there's so many other office memos, so many other formats for office memos. But this is, as was taught by my favorite lecturer, Kungu, Christine Kungu, and equally has been reiterated so many other times. Okay, so after your brief answer, you go to your statement of fact. Yeah, your statement of fact is what would have been your factual basis in a legal opinion. So you tell a story, and then after telling the story, you go to your discussion. Your discussion is your analysis. So you can call it discussion, you can call it analysis, you can call it, I would call it discussion. So your discussion is basically like synonymous to analysis of the law in our legal opinion. That's what goes into your discussion. So you'll be telling us the law is very clear. An employer should, in the DIARA Article 4.1, stipulate every worker has a reasonable working to get reasonable working conditions. You could cite a case if you remember any. Dr. Rutherford is therefore entitled to compensation. Basically, your discussion is in regards to this question. And of course, you're discussing in the light of the law. You remember how you were analyzing? That same way, yeah? So you discuss, you tell us this is the law applicable, and of course, these are the facts, and we believe that in the premise, this particular guy has some alternatives available. And then you conclude, yeah? Maybe you say, having examined relevant laws, Eagle Water Company ordered duty of care to Dr. Rutherford, which they breached, and hence liable to compensate him for injuries suffered. So that's how you would do an office memorandum. You don't need to sign off an office memorandum. You know, an office memorandum, we know you, yeah, it's in the same law firm, it's within the same organization, the same office. So as long as you've written your name over here, then that's okay. And then you don't forget, it's question presented, brief answer, statement of facts, and then discussion, or what we've called analysis, and then lastly conclusion. Conclusion is basically now what's the way forward. Yeah, what do you think we should do? Depending on what you've told us. Yeah, so that's how you'll do an office memorandum. Okay, so I want us to
Lydia, do I sign off an office memo down there?
Yeah.
Do I sign off?
Well, really depends. There might be a mark for signing it off, but it's not mandatory to sign off an office memorandum. But you can sign it off. You can sign off an office memorandum. I've never seen a signed off office memorandum. I wouldn't sign it off if I were you. Yeah, because I have never seen one. Firstly, no one ever signs off an office memo, because ideally, an office memo, you're sending it to somebody who knows you in your law firm. So ideally, you just send this via email, actually, or you print it, you put it on their desk, and it has your name. If they want to confirm authenticity or what you've written, they'll just maybe call you and ask you. I wouldn't sign it off, but it depends on how you're feeling. You would
Secretary, in this unit, are they interested with the substance or the form? In this particular unit, as we approach tomorrow.
The form and substance, the form and substance. You know, you can't have a form without substance. But majorly, the two go hand in hand. You might have substance and then you miss on the form and then you'll fail. And you might have form and you miss substance and you'll fail. You see, as they're marking your, let's say, discussion in your office memo, they're looking out, oh yeah, they know this part is discussion, okay? Yeah, let's give them a tick. Do they know how to discuss? You see, and how to discuss will be answered in the substance. So it's both the form and substance. Okay, so you have to advise your client. You have to write well. You have to use simple English. You have to have advice. Okay, so albeit you're not you don't have, you might not remember these articles, but just show some appreciation of the law. Just say over there, Constitution provides. Yeah, yeah. So it's both, but
Thank you.
mostly, honestly, like 100% format. Yeah, you see, it's about the perception. If I see your office memo looking like this, it has all the parts. My thinking is, you know what you've written. So more often than not, I won't even read this content. I'll be like, unless you have some glaring errors, I'll be like, this guy knows you start with a question presented. Kwanzaa, they've even told us what the brief. They have discussed, and they have a conclusion. Give them an 8 out of 10. So really, it's both, but focus on you. Even if you would rather forget substance and remember format. If you forget a format, it's very injurious. Yes, please.
Sorry, can you scroll to the very top? I just want to see. Does it have a letterhead?
Well, no, it doesn't have a letterhead because it's the same law firm. It doesn't have the name of the law firm.
Okay,
the
so
address
you
of the law
just
firm.
to from date re.
Yeah. So you will write, let's say, to Mr. John. It's from, what's your name?
My name.
Yeah.
Oh, Aisha.
Aisha.
Aisha, yeah.
So you will write from Aisha, yeah, and then the date.
Okay, thank you.
But of course, maybe 2 names. Yeah, for formality purposes, you'll write 2 names. So can we discuss a bill now? I want to check a bill. I want to make it as easy as I can. Because I told you guys I know it will be there. See, I've been telling you that from the onset. And of course, you know, you guys think I am a joke. Mnanizoea. You have no respect for seniority. You don't respect your seniors. But I'm not your senior. We are mates. Some hands are up. Please go on as I get those ninis as I get
Senior,
you. Yes.
I was requesting if you could send us your legal opinion.
Definitely. Yes, absolutely.
Thank you.
I'll send you. Yeah. Of course, goes without saying. Actually, I already sent it. It's on the group. You can scroll up. I sent it immediately after your exam. Yeah, you know, I got you. You're my peeps. Okay, so let's discuss a bill now. So we have 10 minutes.
Thank you, Lydia.
You're welcome. 7:55 we should be done. No, we move to the next document. So just remember, by the way, Sahizi, you know, I don't want to tell you the truth. I don't want you to ignore substance absolutely. Like kabisa, like you're like, I don't need substance. Try to remember parts, like parts of documents. Those will be important, super important, because it seems like you know, even if you have no idea what's going on. Okay, so let's discuss structure of a bill, and then we draft a bill. Now, a bill is okay. So when you want to make the law, or you want to pass the law, or you want to actualize a particular element in our society, let's say you want to give right to lactating mothers, you want to increase maternity leaves, you want to amend our Children's Act, you want to do something, okay, or you want to introduce an act, you want an act of parliament, you start by drafting a bill. So a bill is what mutates into an act of parliament, okay? So structure of a bill includes, number 1, preliminary provisions. Preliminary provisions are those very initial provisions. They're not substance, yeah? They're not really your substance, but they're your like, that I'll show you what preliminary provisions are. There are a couple. And then after your preliminary provisions, you go to your principal provisions. Your principal provisions include the substance provisions and other provisions called administrative provisions, okay? And then we have miscellaneous provisions and final provisions. Well, you could call miscellaneous final. Sometimes it is used interchangeably. You could say final provisions or miscellaneous provisions. So those are the parts of your bill. Okay, so briefly, we could discuss each one of those, but we are going to discuss as I show you what they are. Okay, so it becomes easier. So your preliminary provisions include, number 1, arrangement of sections. That's the very first thing in any bill, arrangement of sections. I've told you guys a couple of times that arrangement of sections is what you would call a table of contents, but now it's called an arrangement of sections. And then it has a long title. A long title is a description of the bill done in a very general way and basically shows the intention of the bill. Okay, so there is a way it is couched. A long title is couched in very, very, very specific words. This is how you couch a long title. You'll say a bill for. You start with the words a bill for an act. That's how you write it, like that. I have no idea why, but you will say, okay, I'll show you in an actual bill. But don't forget the purpose of a long title. It's to basically describe the intention of the bill in a very general way. So after saying a bill for an act for, you proceed and say it's a bill for an act to provide for the promotion, development, and regulation of micro and small enterprises and for connected purposes. So all your long titles, they have to end with these words, and for connected purposes. Okay, so that's a long title. And then we have this, by the way, preliminary stills. We have a short title. A short title is the name of the bill. Is the name used to refer to the bill. For example, we would say the children's bill 2020, or the law of succession bill 2020. That's the short title. Short title, as the name suggests, it is short. It is the name of the bill. And then you'll have your preamble. Your preamble is a recital. It basically shows the spirit and principles behind the law. But you do not need it in an exam bill. You don't have time for preambles. So I'll show you the content for your exam bill, okay? And then we have commencement provisions. Commencement provisions are maybe when will this particular bill take effect? For example, the date of commencement. And then we have the definition section. Definition sections are usually section 2s. Even if you look at most of the acts, definitions are section 2s. So definition section, there are some of the rules that you have to remember while you're defining. First of all, you have to use alphabetical order. So you will start with, let's say, angel, and then you go to boy, and then you go to cow. So as you're defining, you'll use alphabetical order. And there is a particular way of doing it. Equally, you do not define everything in your bill. You define those words that you've used at least more than 2 times, or words that have a different meaning in your bill. For example, ideally, if we all know that a director means a director of a company, a director for your bill could have a different meaning. It could be the director of the committee. So you have to define maybe the term director. So you do not define all the words in your bill. You define words which you've used more than 2 times, or words which have a very different meaning in your bill other than the ordinary meaning. And a definition defines one word at a time. Okay, so you define one word at a time. And you arrange them alphabetically. Okay, so don't forget definitions. We'll discuss definitions. We are going to an actual bill. And then we have an acting formula. An acting formula is basically, where is this bill coming from? Yeah, is this bill being enacted by the Parliament of Kenya? You know, counties can equally enact. Counties can make the law. So an acting formula is basically for purposes of showing which legislative authority is enacting this legislation, or where is this bill emanating from. So you could say enacted by the Parliament of Kenya, enacted by the county government of Bungoma, because counties can equally make law. They can make their own laws. Okay, now principal provisions. Let's just discuss a bill. Let me get a bill. I'll just be telling you what, Cindy, as we discuss an actual bill because of time. So we're going to use this bill. The bill is called Nuclear Atomic Commission Bill 2021. This and another bill, I usually use those 2 bills. There's another bill. So we will use this bill, but I'm going to share another bill with you. So for any bill, if you're drafting a bill, the first part of your bill is the short, you remember, well, not short title, the name of the bill. the name of the bill is the very first thing you write. And you know, this is actually, but then let me tell you the truth. If you've never drafted a bill, you have to remember the way it is over here. So no matter what you do, you have to remember the first thing in your bill is the name of the bill. Like the first thing you start by writing is the name. And now you come up with a name. Now, let me tell you, honestly, I have struggled. Every single time I want to come up with a name, it's either too lengthy or it is very short. It's not making any sense. So I was told that the easiest way of couching the title of your bill is by using the problem and the solution. I'm not sure how true that is, but it works. So you will ask yourself, what's the problem and what's the solution? You might find a name. So the name of your bill, of course, nobody will tell you the name. It's you who's writing the name. You have to come up with the name of your bill. So it could be the Nuclear Atomic Commission bill. It could be stray dogs bill. It could be lactating mothers bill, you know, the children's bill, you know, it could be any bill as long as it shows the intention of your bill. And after your name, you put the number, the year. So it will be 2023 if you're drafting a bill tomorrow, unless otherwise stated in the question. So it'll be whatever the name of the bill, 2023. And then you go to arrangement of clauses. So arrangement of clauses is the second thing you write. And I've told you, you can call it, don't call it that, just in the back of your mind. It's like a table of contents. It helps you know where exactly everything is. So it's more or less a table of contents, but now you wouldn't be saying it's a table of content. It's called arrangement of clauses. Basically shows how are your clauses consequently arranged in your bill. And then after writing the word arrangement of clauses, because you're not even thinking at this point, you're just writing, after the name, you just write arrangement of clauses. You start arranging your clauses. So you will write the word clause here, because you see here 1, 2, 3, 4, these are called clauses. So you write over there clause. And then you start with part 1. Part 1 of any bill is what we've called preliminary. So preliminary only in your exam, it only has 2 clauses. So part 1 has 2 clauses and nothing more. You don't have time. So part 1 has 2 clauses. Clause 1, short title. Clause 2, interpretation. And nothing else. So over here, what you're doing is just writing the contents of your bill, and you're not discussing them. Like really, you're just setting out a table of contents, quote unquote. And then you go to part 2. In your part 2, for any bill that you'll ever draft, all of them, by the way, they look like this. Of course, name will be different. And then you arrange your clauses. You tell us, my clauses are as follows. And then part 1, preliminary. And then you tell us clause 1 will be short title, clause 2 will be interpretation. Short title is what we call is the name of the bill. Interpretation is your definition. So you go to part 2 of your bill. Part 2s of bills are usually establishment of bodies for any bill, because your bill, there has to be a body which enforces the provisos in your act. So part 2 tomorrow, if you're drafting a bill, you're establishing a body. You can elect to establish an authority. You can establish a commission. You can establish a tribunal. You can establish any body on part 2. But of course, highly likely, either establish a commission or an authority. That's the establishment of, you call it, it has to have a name. Establishment of, let's say, public participation authority or public participation committee or nuclear atomic commission, whatever. Of course, it will now be relevant to the name of your bill. So part 2, you're establishing the Nuclear Atomic Commission in this particular in this particular bill, and then clause 3. So you write part 2, and then you go to clause 3. You know, clauses, it's a continuation over here. So we left at 2, our interpretation. So you go to clause 3. Our clause 3 is establishment of Atomic Nuclear Commission. So if you're establishing a body, you start by establishing. You start with a clause on establishment. For example, now you say there is established a commission to be known as Nuclear Atomic Commission. So start by establishment. You will say establishment of the Atomic Nuclear Commission. And then you go to clause 4. After establishing, you compose. You will say composition of the commission. After composing, you qualify. So you'll say qualifications for appointment as a member of the commission. And then clause 6, you'll go to the functions of the commission. So you start with functions and then powers, not the other way around. First of all, you give them duties and then you give them powers. So you wouldn't start with powers and then functions. It is a function and then a power later. Well, you could have tenure of office, but really, you don't have that tenure of office. Just establish the body, compose it, qualify the members, state our functions, and then the powers, and then that's it. Unless you want to shine, or rather you have too much time, you can have, which you won't have. Yeah, so just leave it at clause 7. After clause 7, you go to part 3 of the bill. Part 3 of any bill is administration of the commission or administration of the body that you have created. So you'll be saying, let's say you can have a secretary to the commission who runs day in, day out activities of the commission. And then you could have staff of the commission. Maybe the commission can employ people to work there or to assist in, enabling it meet its obligations. And then you could have conduct of business, but I will only have these two. Just put these two clauses: secretary and staff. That's it. Conduct of business at Channel. And then now there is another part. It doesn't have a name. Immediately after part 3, there is another part of a bill. It's part of the substance of a bill. And it's up to you now, your creativity. Yeah, it's not called administration. It doesn't have a standard term. For example, let's say it's a bill on responding to infectious diseases. You could have a part on reporting mechanism, or maybe a part that provides for rights of guys who are held in quarantine, or maybe provide for a duration which you can be held at quarantine. Like it's okay. I'll show you in one of the bills, but after part 3, you don't go to your miscellaneous. It's advisable you have that, but it could be right of let's say this bill is right of all citizens affected by nuclear atomic activities. It could be mechanism of reporting, like that part. It doesn't have a name. I am really trying my best. It doesn't have a name. So I'll show you one and how to couch it, but it depends with the bill and what the intention of the bill is. If the bill was for purposes of making sure lactating mothers are able to get leave days, in so many leave days in a year, they can lactate at the workplace, then you will have an entire section part dedicated to right of lactating mothers at the workplace. So it depends with your purpose of your bill. So you put that particular part. You get my point? So after part 3, you go into that particular substantive section, which I don't have a name for. And then lastly, now after that part 4, this will be your part 5. Part 5 is miscellaneous provisions, or what you called final provisions of your bill. So your miscellaneous provisions, you just have number 1, financial provisions, and then you'll have offenses, and then regulations. I can't type on this book, on this particular document, because it's PDF, but you'll have financial provisions, offenses, and regulations in that order. And then the last part of your bill would be transitions and saving provisions. Transitions and saving provisions are those provisions that are meant to make sure that, you see, whatever was being done in this previous act, maybe there will be an entire overhaul of an act pursuant to this bill, if at all it is actually assented to, then you want to make sure whatever was there before is not entirely lost. Like there is a way to save what was there, like what you are calling an act having retrospective effect. So a saving clause is meant to provide for the way forward on an act that has been repealed. Okay, that's why it's called a saving clause or a transitional clause, that will enable us to transit maybe from this particular act into a new act entirely. Okay, but basically, as you're drafting a bill tomorrow, don't put that part. Yeah, the saving and transitional provisions, do not put, they are meant to preserve existing laws, address issues of office bearers that were in the previous act, what will happen to them, and maybe repeal a law, but you won't need them. So let's go into the content of a bill. That is, okay, so your bill would look like this: the title, arrangement of sections, and then the clause, and then part 1, preliminary, and then you'll only have two clauses in your part 1, the short title and interpretation, and then you'll have part 2, which is establishment of a body. Like, you will establish a body, doesn't matter what kind of abilities. And then after you establish a body, you go to part 3, administration, and then there is that other part I told you guys. Remember, part 4, I'll show you how you can couch it, and then maybe rights, maybe mechanism of procedures, mechanisms, rights, duties, obligations. That will go into that particular part. It's substantive part of your bill, like it's substance. It's an important part of your bill. And then lastly, miscellaneous provisions, and then lastly, you could have saving and transitional provisions. Okay, that's the last part. And then you could have schedules. If you're able to remember those parts as they are, you can draft any bill, because consequently the contents are simple, because your content will be premised on this particular table of contents. Like, the main content, the main body of a bill is based on what you have in your table of content. You just be copy pasting and filling in details. So if you understand the table of content, you're set.
Excuse
Not
me.
even understanding, like, if you can remember the parts. Yes, please go on.
Right on the page where you are, when you wrote part 1, preliminary,
Yes.
there is no dash, but in part 2, between those words, there's a dash, and then subsequent headings, there are no dashes. Which is the position of that?
You put a dash. Because it's part 1, preliminary. You put a small dash. Is it called a dash? I think it has a name. It's called
It's called a long hyphen.
Long hyphen. You put a long hyphen. Yeah, that's the correct procedure. You put a long hyphen and then you write the word. I'm not sure whether they will take in attention to those, but it's important for you to remember.
Lydia,
yes?
I have a question.
Yes,
in terms of the content we've discussed, please advise. I saw a question that told us to draft a bill, but it told us to not have more than 7 clauses. So maybe the most important clauses that you would advise in the event the question is phrased like that.
Okay, so firstly, it would depend with the intention of the bill. Maybe the facts are leading you towards a bill that provides for very specific things. For example, let's say provides for a very particular body. The question will require you to do something particular, and therefore your bill would be meant for that purpose and that purpose alone. So how your bill would look like, you will have arrangement of, like, this has to be there, and then your clause, you can do away with interpretation entirely. Okay, but a short title is a mandatory part of a bill. However, you can't have a bill without interpretation. So I would have these two, and then I would look at the question and ask myself whether I need to establish a body. If that question doesn't allude, or maybe I don't require a body, in that question, I would do away with that particular part, and then I would maybe go to my part 2 would be substance as per the question, So you pick out what the intention of the bill in that question, and then you provide for that in your bill and nothing more. So it means if the examiner was looking out for 7 clauses, whatever they had in the question was meant for those 7 clauses. Like, it will have been sufficient for you to fully address or maybe remedy the problem with that bill using 7 clauses. Yeah. So it really depends. You can show me the question, and then I will be able to tell you the clauses I would have put. But your part 2, there's some parts you can't dispense with, especially short title interpretation. That has to be there. Yeah. So what will be different in your bill such a bill that you're limited in terms of the clauses is this substance over here. You could either do away with this, put what is in the question, you could do away with administration, but miscellaneous equally has to be there. So what will really change in such a bill will be your part 2 and part 3. So your substance could be different depending on what the examiner has told you, but miscellaneous has to be there, like financial provisions and offenses. You could or you could reserve one clause for your miscellaneous, but miscellaneous has to be there. Otherwise, your bill wouldn't be a bill without a miscellaneous. You could reserve one clause, and then most of the clauses go into your substance, depending with what the examiner wants you to do. So unless I see it, I'm not able to advise on what clauses will go into such a bill, but unless I see it.
Okay. I think I can type the paper.
Okay.
Yeah, on the chat, and then maybe we look at it.
Yeah, definitely. Please do.
Lydia?
Yes, please go on.
Sorry for interjecting. Just a quick question. So tomorrow, for purposes of drafting, you said we do not have to include the transitional and savings provisions, right?
No, you do not. You don't need it. Yeah, you actually need transitional. You will need it if the examiner tells you need it, but you ordinarily don't put it in a bill. Yeah, do not, unless the question says your bill has to have transitional provisions. I'm going to show you how to draft it, but you really don't need it for your bill. Okay. Okay. So have we? Yeah, please go on. Yes.
Sorry, I have a question.
Okay. Yeah.
When you're asked, when you're asked to draft like a clause, just a single clause, how do you go about it?
Well, you just draft that clause. Okay, for example, let's draft clauses and then we see how we will draft a single clause. Sindio. So we are drafting clauses now, and then we'll see how you just extract one.
Sorry, before we go to clauses, real quick.
Yeah.
So we don't need a long title at any point when it comes to drafting, right? So the nuclear
you need a long title. This is the first part of, we haven't started discussing the body of the bill. This is like a table of contents.
Yeah, but the title now is that the Nuclear Atomic Commission's Bill 2021. Ideally, that's where you put the long title.
No. So we are putting it on the next page. So
Okay,
after writing, So after writing, So we discuss the bill and then we come back to questions. Maybe most of them are actually premised on what you are going to do next. Cindy. Okay. So the next part of you, after writing all, yes, please go on. Yes. Yeah.
I think we are guided. Proceed to discuss the substantive bill, then we can come to questions so that we don't lose the focus.
I agree, absolutely. Okay, so but you've understood the by the way, this is like just a shell. Yeah, the first part, like this entire what we've been discussing is a shell. Albeit it's the most important part. If you can draft that part, you'll draft everything else effortlessly. So after drafting that part, we go to our actual bill. That was the table of contents, as I told you. You go to the bill now. So in your bill, you write the title again. You write the short title. You remember the name of the bill. So what you have as your name is the Nuclear Atomic Commission Bill, 2021. Okay, so you write again the name. So you write a table of content, you write all that, arrangement of clauses, part 1, part 2, part 3, part 4, part 5, and then you go to your actual bill now. So you will start with the name, the title rather, it's called a short title of your bill, and then you will go to the bill 4. You remember what you called a long title? That is where you're putting it now. So you say a bill 4, I've been telling you guys, it's heavily borrowed from England. You just say a bill 4 for no reason. You put it there like that. The word a bill 4 seems very incomplete. I agree with you, but it has to be there. You say a bill 4. After saying a bill 4, you proceed and say an act of parliament, and an act is in capital letters. An act is in capital letters, an act of parliament to establish the Nuclear Atomic Commission, to provide for powers and functions of the commission and for connected purposes, and then full stop. Okay, so you write your long title, like you see how it's written here, just like that, Don't overthink it. So it's just like that. And then after you write that, you go to your enactment formula. What you were saying, who is preparing this bill? Is it from the county assembly? Is it from the national government? So enacting formula is couched as enacted by the Parliament of Kenya as follows. It could be enacted by the county government of Kisumu as follows. It could be enacted by the county government of Isiolo as follows. And there is no county there. So after enacting it, you proceeded. And now what you're doing after this part, you're basically copy pasting your table of content. Okay, don't call it a table of contents, that bad behavior. The arrangement of clauses. You're copy pasting whatever is up here. Okay, of course you can copy paste, but I'm using that not very literally. So you take this here, let's say that you copy paste this entire thing over here first. Yeah. And then you come, scroll down, you paste it. So you start with what was in your part 1, in our table of contents, in our arrangement of clauses. So that is what we are starting with. Now we have started.
Lydia.
Yes, please.
I just wanted to ask, now that you are, but I just want to ask about now, what if it's for the county assembly, or so how will you frame it up an act of parliament? How will you frame that if it's for the county government?
Okay, so you say that if it's county government of Nairobi, you say an act of county assembly of Nairobi to establish, and then you go on.
Okay, thank you.
Yeah, so it will be the county assembly. Okay, so you go to part 2, and then enacted, you'll say enacted by the county assembly of Nairobi as follows, because it's the county assembly which will be making this particular bill. It will be tabled at the county assembly. So you start with part 1, preliminary, and then you copy paste. You don't have that luxury of copy pasting, but you basically take what is here, those 2 clauses in your part 1. And then remember, we start numbering now because the clauses had numbers.
Could you slow down kindly?
Oh, yeah. I can scroll down. I slow down.
You slow down. You're way too fast.
Okay, definitely. Okay, maybe we'll take it again from here. So I was telling you guys that you will write the title of your bill again. After you've already arranged your clauses, like this is like a table, ideally exactly how you would do a table of contents. But now your table of contents has very particular details, okay? So after you finish your table of contents, after you finish the table of contents, now you start on another page. You write the title of your bill. So our bill is called the Nuclear Atomic Commission Bill 2021. And then you will write the words a bill for, albeit it seems very incomplete. Actually, it doesn't make any sense, but you have to write a bill for. You write like the way it is written here, the word a bill for, and then you leave it at that. This is what we called our enacting, our long title. From here,
Lydia, we are not seeing anything.
Oh Lord, you're not seeing anything?
Yes.
Okay, let me stop projecting then again. Okay, you can see now.
Not yet.
Yes. Oh Lord.
I can
Maybe
see.
log out alafu project. I can see.
I can see.
Okay.
Yeah.
Yes. Sort your maybe network because of the rain. Okay, so this is, oh Lord, we have to pick pace. So please mute. Check whether your mic is unmuted and mute ASAP. So this is what we called a long title here. Whatever I'm highlighting right now, let me just use a different color. Oh my God. Please mute. Please mute that guy who's unmuted. I've given you the power to mute people who are making noise. Okay, so this is what I'm calling a long title over here, highlighting in yellow now. you'll start by writing a bill for, and then you'd say an act of parliament. If it's the county assembly, you say an act of the county assembly of whichever county government to establish the Nuclear Atomic Commission to provide for powers and functions of the commission and connected purposes. Like briefly, what is your bill meant to achieve? Like the intent of your bill. The intention of your bill is, well, it will be different depending on the question. It can be, a bill is meant for purposes of providing rights to our soldiers who we send out to Haiti and Somali. So you write the purpose of your bill in those precise terms. That's how you couch a long title. You call that a long title. So a long title is the title, or rather a paragraph. Yeah, a paragraph which shows the intention of your bill in very precise words. And remember, you start by saying a bill for I don't know whether it makes sense to you, but you write a bill for first, and then you will go to an act. And this is in capital letters. Oh Lord, it's too dark. This color is too dark. You will say an act of parliament to establish the nuclear. Just say what it's meant for. And then the last sentence has to be, and for connected purposes. So whatever your act is meant for, the last sentence, or rather the last part of your long title is, and for connected purposes, and then full stop. So after your long title, you go to your enacting formula. We call this an enacting formula. Basically shows where is this act coming from. It shows the authority of whoever is now bringing this bill. It can be either the parliament, can be your county. And then after your enacting formula, you go to your part one. So you basically start now on the substance of your bill. And what you'll be basically doing, you'll be copy pasting what is in your arrangement of clauses. I don't want to say table of contents. So you'll be copy pasting what is in your arrangement of clauses. So for example, here part one, preliminary, it has two clauses. It has clause one, short title, clause two, interpretation. So this is exactly what we are going to have in part one of our substantive bill. So it's basically like copy pasting those two clauses. So we will start with clause number one, which we called a short title. So tomorrow you'll draw a line with a ruler over here, like a very straight line going down. You draw a line, just like that. Okay. So the reason you're drawing a line is because your work will be too messy. You're writing with a pen. These are called marginal notes. You see here, short title, interpretation, they're called marginal notes. And marginal notes are meant to guide the reader, So be able to know without reading the substance of your bill. If I see on your marginal note the word short title, I would know that what you have is a short title. All legislative instruments must have a marginal note. And they're usually found on the right-hand side of your clause, your section, your regulation, your rule, and they offer a general synopsis of what is in the content, the actual body of your bill. And they have to be accurate and not contradict the content. So if this is a short title, don't write a long title. So you'll start, the minute you start numbering your clauses, you start writing the marginal notes. Every clause has to have a marginal note. For example, clause one is what we called a short title. If you go up there, you'll see that we called clause one short title. So the word short title will appear on our right-hand side as a marginal note. And you have to draw a line for a very simple reason. Your work will be very messy. You can imagine writing with a pen alafu hauna hii laini. What will happen to your answer booklet? We will not distinguish the content and where your marginal notes are, where they begin, where they end. So we start with clause number one, which we've called our short title. So we will say this act may be cited as the Nuclear Atomic Commission Act of 2021. So that's the first clause. And of course, I'm telling you, the clauses have to be in consonance with our arrangement of clauses. So you'll start by telling us that now, This act, remember, this act may be cited as the name. You write the name of that particular act. And the reason why you're alluding to an act is because after it has been enacted or after it has been assented to by the president, it becomes the law as it is. So you'll be alluding to this act may be cited as the Nuclear Atomic Commission Act, because the minute we assent to this, we are going to assent to it as it is. Okay, and then you go to your clause 2. Your clause 2 was interpretation. So our interpretation section, you will start by saying, in this act, but they don't allude to bills in the body. I'm not sure how to delete this. Oh my God. Just ignore. Oh Lord. Maybe we can just try and put a very heavy color so you guys don't see it. So in this act, you say this act, don't allude to bills, because this will be, as I've told you, after being assented to, it becomes the law. Yeah. So in this act, unless context otherwise requires, in those exact words, you know, you're not going to say herein below the following words mean, yeah, you say in this act, comma, unless the context otherwise requires, and then you proceed to give your definition. So you start with alphabetical order. The word advocate, you start with advocate because you have an A. It has an A. So you remember these English aid manenos, opening speech marks. So it has opening, Lord, are they even called opening speech marks? Somehow you were lied to. Those two, you guys can see, as long as you can see, these two marks over here, you put them there. So you write advocate, the word advocate, the name advocate. So unless it's a proper noun, do not write like with a capital letter. For example, you can't write advocate with capital A because it's not a proper noun. You remember nouns? This is the time. So you write, okay, it's not injurious, it's okay. If you are not sure if it's a proper noun, it's being used as a proper noun or not, then you can just write advocate. So advocate, the opening speech mark, means an advocate of the High Court of Kenya whose name is duly entered upon the roll of advocate and has been in active practice for at least 5 years. Oh Lord, don't put a question mark over there. You would put semicolon. This it's called a semicolon. But if I say semicolon, you check what I'm alluding to. I might be saying semicolon, it's a full colon. So these 2 marks over there, like a full stop on top and a comma at the bottom, you put those. So after every definition, you put at the end, comma, Lord, you put like a full stop at the top, semicolon, you put a semicolon, and then you go to your second definition. You go to your second definition. So our second definition is cabinet secretary, means, and then we define our cabinet secretary. Cabinet secretary, for the time being responsible for matters relating to energy. And then we put our semicolon. We go to the third, don't put a full stop here. This is wrong, but I can't delete it. You know this PDF. And then you go to the third definition, chairperson. Chairperson means the chairperson of the commission as appointed in Section 5 of the Act. Section 5, and you know you're referring to this particular Act. Section 5 of this particular, Section 5 of this Act. And then you put a semicolon, you go to the next definition. Like you define all your definitions, you tell her, and you lose, this is how you couch it usually. Management means, commission means, nuclear energy means, nuclear plant means, secretary means. And then as you are defining your last definition, let's say you're almost now getting to your last definition, you're on your second last. For example, our second last definition over here is nuclear plant. So you say nuclear plant means a nuclear energy reactor and related facilities. So instead of putting a semicolon and leaving it at that, you would continue and say, and you put the words end, like A and D. And then after saying end, you proceed and define your last definition, like you define your last word, sorry. So before you define your last word, your second last word she will have a semicolon and the word end, because AND connotes that now this is your last definition. Like you want to define your last word, you move on. So you define your last word and then you put a full stop. Like over here, like you put a full stop, like immediately after the word act, you put a full stop. So there's those rules. I had shared with you rules for definitions, but most important for bills is alphabetical order. Don't define a lot of terms. Define those words that you've used at least more than 3 times, or they have a different meaning for purposes of your act. Otherwise, if it's a word which everyone knows, for example, being sued, you can't define sued. Everybody knows the meaning, so there is no need of defining unless it has a different definition in your bill, in your act. So that's how you would have your clause 1 and clause 2. Do you have a question? And after every clause, you put a marginal note over there, like on the side, you put a marginal note. You'll have to draw a line. I'll show you kidogo, where a booklet that has a line and has marginal notes, how it looks like. So you write a marginal note. This shows it can be definition, can be interpretation. So every clause has a marginal note. Okay, so after your definition, you go to part.
Question.
Yes, please. Yes.
Yes, I'll just be quick.
Yeah,
now in
sure.
the definitions,
Mm-hmm.
Can you include that part of unless the context otherwise requires, and then you state now each and every part that you want to define?
So here, clause 2, you say in this act, unless other context otherwise requires.
Okay. Okay. Yes. That is what I was looking for.
That's sure. You will say unless context otherwise requires, and then you start defining now. Don't define more than 2 words tomorrow. You don't have that time. Just the examiner wants to see whether you know the rules of defining, and your bill has to have a definition section. So define 2 people. 2 words, and then move on. So don't define more than 2 people. Just have a lot of definitions. Just kidogo definitions. At most maybe 3. Yeah.
Can you say child, meaning child means as defined in the Children's Act?
Yeah, you could. Yeah, it's allowable. But a child only has one definition. So that particular it's not disallowable, because you as the drafter, you're the one who knows why you need to define a child. Otherwise, everybody, if you go to the Children's Act, the definition of a child is only to be found in the act. Yeah, in the Children's Act. But you can define it if it's necessary. You can say a child for the purposes of this act means a child as defined under the Children's Act. It's allowable. It's allowable for you to define. And there's an act called Interpretation General Provisions Act. It has a lot of definitions. If a definition is there, don't define it. But you can define any word that is for purposes to enable us appreciate your act. Suddenly we need it. So we go to part 2 after part 1. Our part 2 is where we are establishing a body. So in our part 2, of importance is our marginal. So let's draw. It was yellow. So you draw a line on your booklet just to make your work neat. You draw a line over there. Oh my God. Oh Lord Jesus. Yeah. I'm not sure what to do. You draw a line, you get a point. I'm not unable to undo what I've done, but just draw a line for purposes of your marginal note, going all the way down. And then you start with, we were higher. If you go to our table of contents here, we established first, and then we composed, and then we qualified, and then we had functions, and then we had powers, and then we had tenure, just like that. So part 2 of our substantive bill is actually a reflection of what you have there. So we will start with establishment of a commission. So that's our marginal note. So our clause 3, you could have subclauses. So this clause 3 has a subclause over there. So it is 3.1. There is established a commission to be known as the Nuclear Atomic Commission. So usually, you say there is established. Don't say there shall be established or there will be established. It is there is like present continuous tense. There is established a commission to be known as the Nuclear Atomic Commission. And then, so that's your establishment section, just one sentence, and then you write your marginal note on the side, on the right-hand side of your book, of your answer booklet. And then you can proceed and tell us what the commission can do. Yeah, you could say the commission is a body corporate and is capable of, number one, being suing, acquiring, holding, borrowing, lending money. You can tell us that. However, it's important to say it's a body corporate with perpetual succession. If you don't have a lot of time, it will suffice for you just to say the commission is a body corporate with perpetual succession and a common seal and shall, oh Lord, and shall be, and then you like put a full stop after the word seal. If you don't have a lot of time, you might to like 5 minutes. Someone is asking for your paper. Those hawk-eyed invigilators are almost eating you alive, and they're asking you to give the paper. If that is what is happening to you, just write the commission is a body corporate with perpetual succession and a common seal, full stop. But if you have time, you can proceed and tell us what it's capable of. It can sue, it can be sued, it can acquire, all that. And then the other clause in our table of content, in our arrangement of clauses, was composition of the commission, what you have on the marginal note. We compose the commission. So composition means you tell us who will sit in the commission. For example, the commission shall comprise of 3 to 5 members, a chairperson, an advocate of the High Court of Kenya, any other member. So it is up to you. There are no rules of who will sit in your commission or your authority. You could say my commission shall have an advocate of the High Court of at least 2 advocates of 5 years. Yes, please.
Quick question. The
Yes.
side notes on the right side, do we have to write those?
Yeah, all legislative instruments mandatorily, they have to have marginal notes. So yes, it's mandatory.
So you have to make space for it. So you write almost half of the page and then write them on the other end.
Well, yeah, something like that. Let me show you something. Can we finish and then I show you how your paper would look like?
Okay,
Yeah?
okay, thank you.
Yeah, I'll show you. I'll make sure to show you. Yeah, but it has to be that. You have a really big handwriting. You're in trouble, but it's okay. I'll show you a paper and you'll see it makes sense. You can like just squeeze it at the very last part of your answer booklet. We'll see how that goes. So after you establish, you're basically copy pasting the contents in the table of contents. You establish and then you compose. You could say shall comprise of 3 to 5 members as follows. You tell us a chairperson, an advocate, like just compose the way you deem fit. There's no rules here. You can decide you want the Attorney General to sit in that commission, or whoever that you want to sit on that commission, or maybe anyone with a degree in atomic energy will sit in that commission. So you tell us who will sit in your commission, okay? And then you could tell us consequently what are the qualifications if you want to sit in that commission, as it was in our table of contents. So you can qualify, or rather give qualifications to persons who will sit in their commission. So you could say a person shall be qualified for appointment as a member of the commission if that person, number A, is a citizen of Kenya. Number B, has experience or knowledge in science-related field. Number C, meets the requirements of CAP 6. Number 4 is a person, an advocate under 7(1)(a). So you have to look at 7(1)(a). But you could just say an advocate of the High Court of Kenya with at least 5 years standing. Yeah. So you tell us what are the qualifications for us to sit at your commission. After you give qualifications, Lord, so you cannot belabor a lot, Cindy, but at least you know how to couch qualifications, something like that. Just say a person shall be qualified for appointment as a member of the commission. If that person, number A, is a citizen, you could have like 3. You could say is a citizen and has experience or knowledge in a science-related field, full stop. You don't have to have a lot of qualifications because, again, you don't have time. So we continue with our marginal note. So we proceed and give functions to the commission. Remember, we give it functions and then we go to, after functions, we go to the powers. It's functions first and then powers. So we will say the functions of the commissions shall be, and then you say the functions. Honestly, the functions of your commission will be different from these functions. It could be something entirely different, depending on what you want to achieve. You see, an act of parliament is usually meant to remedy a problem, to cure a problem. If your act is about, let's say, animals or maybe wildlife, honestly, your commission cannot be for purposes of management of nuclear plants. So it will have an entirely different function depending on the intent of your act, depending on your long title, okay? So the functions shall be as follows. You tell us the functions, number A, number B, number C. Again, don't put 19 functions, just kidogo functions. If you start writing a lot and you belabor the point, you'll lose your way home, okay? So after the functions, you write a marginal note. This clause is about functions of the commission. So we go to the next clause, clause 7. The commission shall have the powers necessary for execution of its functions under this act or any other written law. You can decide to state the commission shall have, or you could say the powers of the commission shall be. As the way you have couched your functions, it's allowable for you to say the commission shall, oh, by the way, as you're couching your functions, usually you can use the word may. I mean, shall. Shall connotes a mandatory duty, and then may connotes a power. So you could say the commission may. May is usually discretional. You can do it or not. It's a power. But shall in any statute connotes that the import of the word shall is that it's a mandatory duty. You have to do it. And the may shows you don't have to do it. So you can say the commission may, if you're giving it powers, you can say it may, and then you list the powers, or you could couch it like this. This will save you a lot of time. If you say the commission shall have all the powers necessary for execution of its function under this act. Yes, please. Yes, please.
Maybe you can clarify something, because able scroll up kidogo.
Okay.
Where the establishment of the commission.
Okay. Establishment was the first clause in part 2.
Yes. So reading it reads, there is established, and then the subsequent clauses, there shall be. What's the criteria there?
Well, when you're establishing, you'll use is. Yeah, when you're like saying there is this particular clause establishment, you will see there is established. I'm not sure which clause would you like clarification apart from this one, but this is how you would ideally establish it. You don't say there shall be established. You know, that's past tense. So it has to be continuous present tense. There is established, because it's being established by these acts now and now. Okay. So these other consequent clauses, for example, composition, you say the commission shall comprise. You can't say the commission is comprised. You will say the commission shall be comprised. You say the functions of the. You wouldn't say the functions of the commission is. You say the functions of the commission shall be. So the only place that you have to remember its present continuous tense is where you're establishing the commission. You say there is established a commission, there is established an authority, there is established a tribunal. You don't say there shall be established, you say there is. However, consequently, you can say the functions shall be, the power shall be, because it wouldn't have, the syntax wouldn't make sense if you say the functions of the commission is. Yeah, I'm not sure whether it makes sense, or you would like maybe clarification. Right of response. It's called right of response. Okay. So I hope it makes sense. So there is established. Okay, there is established a commission. No, there shall be. It shall be. But consequently, you can't say the commission is. Like consequently, you can, if by the way you're giving it a power, you can say the commission may. the commission may do the following. You know, if you're giving it a function, you have to use the word shall. For functions, it's shall, because shall connote a mandatory duty. So, oh Lord, by the way, we have to go on because we might find ourselves discussing bills. So after, but it's very, very important for you to actually get it. So I am willing to, you know, work with you. So functions of the commission, that's your side note, marginal note. And then you give it powers after the power, like every particular clause has a marginal note, like what it's about. A marginal note is like, as I had told you before, it shows the synopsis of a section, like what's basically the section is about. So you write the powers of the commission, and then you could, don't put tenure, by the way, unless the question has told you provide for tenure, otherwise don't put tenure of office. Yeah. So if the question has asked you to provide for tenure of the members of the commission, you say the chairperson of the commission shall hold office term of 2 years, and they can be reappointed. You just decide, do you want the chairperson to sit for 5 years, for 2 years, for 10 years? And you could say equally members of the commission may resign if they want to resign from office. Equally, you can be removed from the commission by the cabinet secretary if you're dead. Okay, if you're declared bankrupt, if you're mentally ill and therefore you can't perform your functions, that will mean your tenure has ended. So you can end tenure by death, by resignation, or maybe if you're declared bankrupt. And you could equally tell us for how long are you going to hold office if you have been appointed as a member of the commission. Okay, so that's how your part 2 would look like. You first of all establish, and then you proceed compose, and then you qualify the commission members, and then you give the commission functions, and then you give the commission powers, and then consequently, you go to part 3. Part 3 is what you called administration section or administration part of your bill. So administration part of your bill, we said we will have a secretary. So the first clause on part 3 would be secretary to the commission. So you could say there shall be a secretary to the commission who shall be appointed from among members through an open, transparent, competitive process. Usually it doesn't have to be appointed by the commission. You can say the cabinet secretary can appoint the secretary. So it's up to you, yeah, to decide how you want your secretary to be appointed. After you appoint the secretary, or after you provide for the position of a secretary, you proceed and tell us maybe what the secretary can do. Very briefly, it's under the same clause, so you could have a subclause. The secretary shall be the accounting officer, shall run the commission day in, day out. And then you could have, now after this clause, secretary to the commission. Most importantly, is telling us there shall be a secretary. After telling us there shall be a secretary, you could proceed and have staff of the commission, which basically means the commission may appoint, you know, we said may, connotes like, it's more or less a power. It's not mandatory. If you're using the word may, it's not mandatory. The commission may appoint such professional and technical staff for proper discharge of the functions of the commission. So it's allowable. So you could grant the commission the power to appoint the staff to the commission, because it will need staff. You'll need like people working there, receiving complaints, issuing licenses, such issues. So you need staff to the commission. And then you don't need conduct. I told you don't need it. And yeah, we could just cancel it. And then after your part 3, you know, part 3 is very short. Secretary to the commission, staff to the commission. You go to part 4, which is your miscellaneous provisions. You can call this particular part final provisions. You can call it final provisions or miscellaneous provisions. Our miscellaneous provision in our table of contents only had 4 clauses. For your purposes, you only need number 1, financial provision. So this particular provision or this clause in your miscellaneous provision is basically showing where are you going to get your money from, because the commission has to run and it has to get money to run. So you could say the funds and resources of the commission shall consist of, and then you tell us where will we get our money. This commission can get money from the government, can get monies appropriated to it by the parliament. Equally, can get money from investment. You can say from borrowing, from members' contribution. If the act has members or act as people can contribute, you see. So you tell us where exactly will this commission be getting the money from. So that's the financial provision. And then you create an offense. It's actually indispensable. Every act has to have an offense. Otherwise, it will be a useless, it will be, what we've been calling toothless dog. You see, this act can provide for so many things, can tell you, oh, you have to actually make sure you apply to the commission while you're dealing with any nuclear atomic material. But what happens if you don't do it? So offenses for any statute is meant to actually make sure there is a punishment for breaching the provisos. So for example, you'd say, a person without permission of the CS who deals in nuclear atomic bombs and any related facility is guilty of an offense and shall be liable upon conviction to imprisonment for 7 years. Now, assuming you had an imprisonment and fine, like you had like a provision for fine, you will say is guilty of an offense and shall be liable. You have to say shall be liable upon conviction because you only become liable for punishment after you've been convicted. You can't be punished unless you've been convicted. So shall be liable upon conviction to a fine not exceeding Kenya shillings 20,000 or imprisonment for 7 years or both. So if you have a fine, but then there is a way you couch your penal clauses. They're called penal clauses. You start with the fine and then you go to the years of imprisonment. You don't start with imprisonment and then fine. It is money and then years that you can take you to prison, and then you lastly say or both. So you create an offense. And by the way, I don't want to stress you, but there is a way you decide how many years you're going to chuck. There is a document I have. The document was prepared by Senior Dimadima. He's called Dimadima. He works at the parliament. He's a legislator. He's an advocate. And it has exactly how you decide how many years to put in your bill. You can't just say 7 because you feel like 7 is good, appropriate. So there is a particular manner which legislators will use to determine the appropriate punishment. For example, 7 years, 20K is fine. I'll share with you the document, but you don't have to overthink. Tomorrow, just write 1 year or 2 years, or just don't write 30 years. The examiner might actually now start looking into that document whether you've actually given the correct number of years. I don't think so, honestly. But don't give a lot of years. Don't be too much. So in your offense, just say maybe 1 year in prison and 20,000 fine. That will suffice, yeah. And then you will equally have in your miscellaneous provision, regulations. You will say, subject to the act, the cabinet secretary may make regulations for better discharging of these acts. That's your regulations. So there are only 3 clauses in your final provisions. You have financial provision, you create an offense and the punishment, and then regulations. That's it. That's it for your final provisions. You just need those 3 clauses and nothing more. Okay. This part is what I was telling you. You don't need to draft. Yeah, you don't need your transitions and saving provisions or final provisions. Transitions and saving provisions, as I had told you earlier, they are relevant if the law is being changed by enacting a new act. For example, we are amending an act, we are repealing an act, like an entire overhaul. So you need saving provisions for purposes of transiting. You want to transit smoothly, and equally for purposes of preserving the existing law or the existing right. Yeah. So it is inserted to apply provisions of the new law to situations already in existence. Like now, what happens to the rest of us who've been who've been citizens by registration, and maybe you've repealed that particular provisions. You can never be a citizen by what happens to those guys who are already citizens by registration? Or maybe you repeal something like the Children's Act. You tell us a child is below 12 years. So what happens to those of us who have IDs? Or maybe there is a change. What happens? Like you address a change, a significant change that is being brought by a new law. So you want to preserve existing law, existing rights. You want to make sure that the situation already in existence is saved. It is saved, or you're providing a transition way of from the old regime into the new regime. Okay, so this is what we call a saving clause or a saving provision. So a saving provision will say any orders, notices relating to administration legally issued before the commencement of the act shall be deemed to have been issued under this act, like something like that. Yeah, or maybe any titles issued under this act previously will be deemed to have been issued as under this act. You see, such a thing for purposes of saving what was already in existence, okay? Because you don't want to throw everything out of the window. That's a saving clause. Equally, in your transitions and saving provisions, you could have a clause to repeal. You could say the Children's Act 2002, shall be repealed upon commencement of this particular act. You could have a clause repealing an entire act in your final provisions. So your final provisions or transition savings provisions, you don't need it unless the examiner has told you to draft it. Do not draft it, okay? Now, there's something very important. Okay, your bill ordinarily in an exam setup, it will end there. It will. That's the last thing. After you finish your bill, you have to sign it off. Sign it off. You have to have a date, yeah, of your bill. For example, you'd say dated March, and then the name of the guy that is introducing it. For example, this guy is called Austin Odaro. He's the parliamentary. You can't be you can't introduce a bill as a council. Who elected you? So it can be a member of parliament, but not a council. Don't write the name of a council there. You know, a council is incapable of introducing a bill at the floor. It's you have to get a sponsor, like someone to help you fast track at the floor of the house, because the legislature can make laws. You and me can make laws. So I don't know, Austin Odaro, I don't know who gave them the power. So let's say Austin Odaro, member of parliament Nyamira, yeah? Or maybe the name of whoever, the guy, maybe let's say Austin Odaro, member of county assembly, member of county assembly, Westlands, such a thing, but not Austin Odaro. So in your question, you will see who's the initiator of the bill, and then that will be the person who is introducing the bill at the floor of the house. Okay, so that will be the last part of your bill. And by the way, it's already 9. We can't continue discussing bills. Cindy-o, Emma, what do you guys think? Oh, there is one more thing about a bill. It's called a memorandum of object and reasons. It's part, okay, after you finish your bill, like after your final provisions, you will have schedules if necessary, but you're not drafting them tomorrow. You will have schedules. One of those schedules, like one of the content of your schedule, is a memorandum of object and reasons. The examiner might tell you to draft a memorandum of object and reasons of a bill without the bill, like just this part. Memorandum of object and reasons is basically a summary of a bill. So you're just summarizing the content of your bill. For example, you'd say the principal object of this bill is to provide for a comprehensive framework for establishment of Nuclear Atomic Commission, the powers, the functions, like a summary of a bill. And then you will tell us briefly what is part 1 about. You see, this is what you call a long title. You just summarizing the long title, telling us more about the qualifications, the procedures of appointment to the commission, and then you tell us part 1 of the bill deals with preliminary matters. You tell us clause 1 has this, clause 2 has this. And then you go to part 2, you tell us part 2 of the bill deals with establishment of the Nuclear Atomic Commission as an independent and autonomous body. And then you go to part 3, you tell us part 3 of the bill deals with administrative provisions, like all the parts we've discussed. You go to part 4, you tell us part 4 deals with miscellaneous matters. You go to part 5, you tell us part 5 deals with savings and transitional provisions. And then lastly, you tell us whether this particular bill is a bill that concerns county governments. if it's a bill that concerns county government, it has to be taken to the Senate. Yeah. So you tell us, does this bill concern county governments in any way? Number one. Does this bill limit fundamental statement on limitation of fundamental rights, statement on whether the bill concerns county government, and statement on whether this bill is a money bill within the meaning of Article 114. So if you're asked to draft a memorandum of objects and reasons, this is what you'll be drafting, like just a summary of the bill from part 1, part 2, part 3, part 4, part 5, and then you tell us whether you have a state, whether the bill limits fundamental freedoms, and whether the bill affects county government, and whether this particular bill is a money bill, yeah, in terms of Article 114 of the Constitution. If it's a money bill, it means it will occasion additional expenditure of public funds, because monies will have to be paid out of public funds into the commission running of its affairs. Okay, there was a question which asked guys to draft memorandum of object and reasons and nothing else. That's how you will do it. Please allow me to send this document to you guys, and then you look at it. However, you could ask questions. But remember, I told you your bill tomorrow, if you've been told to draft a bill, let me show you something and then we move to the next thing. If you've been told to draft a bill, the last part will be this part, miscellaneous, and then you date your bill. You tell us who's the initiator, who's the sponsor. You write the name of that particular member of parliament or whomever is initiating the bill, and that's where you will. That will be the last part of your. That will be the last part of your bill. Let me know. Do you have questions? As I get the paper I told you I would get for you, we could ask questions. We could ask questions. Oh Lord.
Yes, we have questions.
Yes, please go on. Definitely. Go on, just
Must
submit
it
and
be
go on.
attached to must it be attached to the bill? What the
Then?
bill?
No,
Must
no,
it
no.
be
If you're
attached to what the bill?
if you know, we have a part that is called schedules. After you finish the last part of your bill, this particular part over here, transitions and saving provisions, you go to schedules. So usually memorandum of object and reasons is part of your schedule. Like it's part of your schedule, like it's other things, yeah? So memorandum of object and reasons is part of your schedules. If you're told to draft it, you draft it the way it looks here. There is no bill. You just write memorandum of object and reasons, and then you start drafting. You start telling us the principal object of the bill is to interdiara. That's what a memorandum looks like, the way it looks here. You're not going to draft any bill, just the memo, the way this one-page document over here. But it's part of a bill, yes. However, if you're told to draft a memorandum, you draft this memorandum. But in an exam setup, okay, let me show you something, maybe to help you contextualize. Okay, so let me project something. Oh Lord, we have to move to the next thing. You know, I promised you guys you won't be here by 10. So I have to keep my promise.
Lydia, I had a question.
Yeah, please.
And my question is, do you have a format? Do you have a sample for drafting legislative legislative that one for legislative drawing?
Hey, see Tulia Evans banner. See, we are getting there.
Okay.
Easy, relax. I got you. One step at a time. You can't chew too much at the same time. So just relax. I got you. Okay, so I want to show
Lydia.
Yes, please.
We have covered drafting of a bill, but you were supposed to mention something on amendments.
Yeah, I will. Oh Lord.
Okay.
I will. So I will mention amendments. You know, I know you're stressed, but I'll make sure to mention everything. So don't worry. Sahi too. Okay, so this is how a bill would look like in your exam paper. Of course, the question will be, let me show you. The question will be take into consideration, okay, something along those lines, and then prepare a bill that would adequately align with the above objectives of the government. So this is how you will draft a bill. That bill was 20 marks, okay? This character got 20 out of 20 in the bill. So you will draft a bill like this. It will be the title, the way we've done it, like draw a line hapo kando, unaona hapa hivi. And how are you going to draw a line without a ruler? Ama you're going to borrow. So you draft, okay, you draw a line with a ruler. And this line is meant for your marginal clauses. So you draw a line, line on every particular page you're going to have a bill. And then you start with your title. You see a title is 2 marks. You know, you might think coming up with a title is so easy. Where? It's not easy. So you write Public Health Emergencies Bill. This was the name of that bill. That's the name they came up with for the bill. It was 2021. You arrange your clauses. Like you write arrangement of clauses, just the way we've done it. And then you write the name clauses, the word clauses, sorry. And then you start with part 1. Part 1 will have your short title, interpretation. You don't need object and purpose of the act. That will be captured in your long title. So just put 2 clauses here. Short title, interpretation, and nothing else. And then you go to part 2. You establish a body. Remember, we have to establish a body. You can decide to call it an authority or a commission, but don't call it a committee. Committee sounds funny. So just call it an authority or a commission. You establish a body there. And then after establishing, you start with your clause for establishments, functions. You could have powers, compose. Oh Lord, this is all over the place. Makes sense for you to establish first, and then you compose. And then you go to functions, powers. The way, don't change what we've done, by the way. I don't have the other bill, but this is just quite, well, everything is there, but a little bit mixed up. And then you go to part 3. Part 3 is what I was telling you guys I don't have a name for. You remember that part for maybe rights, procedures, that's your part. It could be your part 3 if you need it. For example, here, it was measures for containment of public health emergencies. And then you put contents here. For example, this guy put a statement of limitation of rights, limitation of freedom of movement. They have entry to the country, operations of, oh Lord, educational facilities. They have that. So they have that in their part 3. It was necessary to maybe create some procedures, you know, how to deal with anyone with COVID. And then it has this particular part, financial provisions. That's their last part. The financial provisions part, you put it together with final provisions. Like final provisions would include financial provisions, offenses, and regulations, those 3 parts. Because financial provision is part of your miscellaneous or final provisions. And then now you write again what we did. You write the title, a bill for the long title. You go to enacting formula. It's enacted by the parliament. You see, you write here a bill for, like that. And then you tell us what it's meant for. And then you say for connected purposes. And then you start with part 1. You write after the minute you start numbering your clauses, you start introducing marginal notes. Okay, so every single clause, marginal note. Every single clause, marginal note. Oh Lord, they have 4 marks for definition. So you say opening speech marks, semicolon. And then before you define your last term, you say end. And then full stop. No one marked object and purpose of the act because you don't need it. You see it is struck out, not struck out, like underline, cancelled. Not what you call this. Like there are 2 lines there. And then you go to establishment of your authority. They first of all establish the authority. You see, you say there is. Don't say there shall, you will get 0. And you see establishment is 2 marks. Most people will say there shall, the guys who are not in this class. But you guys, because you're the G's, you say there is established and not there shall. Oh, what is there shall? So you say there is established, okay, a body. Like you say the name, and then you can say the authority shall be a body corporate capable of suing, all those in the DRA. And then you have functions of the authority. You can say the authority shall have the following functions, or the authority shall be mandated to. And then you say the function, their membership. No one marked the composition. I think it was not needed. You see it's not marked. My God, they didn't even get a mark for qualify. This is really bad. I'm not sure what's going on in there. But everything here is not being marked. Even this was not, my God, part 3 was not marked. So you can see you don't need a lot of content, but just do as much as you can. Yeah, nobody marked part 3, like nobody marked that. Nobody marked final provisions. My God. Yeah, there is no mark there. Oh yeah, nobody marked the financial provisions, what they've called financial provisions. No one marked it. You know, you just put financial provision, not as a part. It's a clause in your final provisions. Okay, so there is an offense here. Any person who in the da, upon conviction shall be liable to imprisonment for a term not exceeding, oh Lord, them they've imprisoned first and given a fine. I think whoever was marking missed it. First of all, it's a fine and then imprisonment. So don't make that mistake. You know, you might not be so lucky. And then regulations. And then lastly, they provided for memorandum of object and reasons. Nobody marked it. Don't do it. Don't put memorandum of object and reasons unless you've been told to put it by the examiner. And then your bill is dated. And then this is John Kamakua, leader of majority. That's how you'll do a bill. So you'll don't forget to like draw that. Just use the formula the formula. The contents we've discussed here with you today, in that order. Don't forget either of them. So let's mention amendment. Let's mention amendment before we go to the next thing, amending a statute. If you've understood a bill, you know amending is just an amendment bill, but now what you're doing is you're amending. It's like a new bill. Okay, so just let me get some slides on amendment of a bill, which slides I shared with you guys. So that's how you will draft a bill in an exam. Don't say authority shall be established. It is authority is established. Okay, just one quick. Yes.
Quick question.
Yes, please.
Which document is that one that we are using? Which year?
It's 2021 June.
2021 June.
Yes.
Oh, thank you.
All right. Okay. So it's 2021 June. You can find it on CLE's website.
Can you kindly share it on the group?
Yeah, I'll be able to share after the class. But let me show, you can find all those best performed papers on CLE's website, all of them. So you might need to look at these years, last year's, they're all there on CLE's website, but I'll equally do share that one. Okay, so amending legislation, you'll use amendment bills. Okay, so amendment bills are meant to amend. Yeah, for example, the most recent one is the one that you guys are familiar with, would be the Law of Succession Amendment Bill of 2020. There was another one for 2019. Yeah. So an amendment bill is used to amend a statute. We have a statute already and we are amending. Okay, so you'll use these slides are prepared by the guy I told you guys. It's called Dima. He's a principal legal counsel at National Assembly. So if you want to amend, I'm just going right into how to amend. Cynthia, you have to know the nomenclature of amendments. Nomenclature is how you refer to sections, how you refer to statutes, how you refer to clauses. In a constitution, the nomenclature, you cannot draft unless you appreciate the nomenclature. And you might think you know, but don't I have a story for you? So in a constitution, you refer to articles, you refer to clauses, you refer to paragraphs, you refer to sub-paragraphs. I know you guys on a daily, you say article 2, sub-article 1. There's nothing like a sub-article. It's a clause. Okay? A sub-article is a creature of your own fertile imagination. So you will say article 2, clause 4, paragraph A, sub-paragraph 3 of the Constitution. So never will you be heard. If you're in this class, never say article 2 sub-article 5. It is article 2 article 2 clause 4, or whichever clause you're referring to. Of course, for Act of Parliament, it will be a section, a subsection, a paragraph, and a sub-paragraph. Okay, that's how you would, for Act of Parliament, I know that's easy. You will say sections, you will say subsections, you will say paragraphs, and lastly, sub-paragraphs. And I think you guys can see if you're numbering a section, there's maybe a 2. The way the 2 is written here, just 2. If it's a 3, it is a 3 that is enclosed, you know? Our subsections are like enclosed. And then paragraphs, they're alphabet, like A, B, C, D. And then subparagraphs are usually Roman numbers. So if you're numbering a section, a subsection, a paragraph, or a subparagraph, the numbering will be different depending on what exactly you're numbering. Sindio. Okay, so I want us to amend now. I just want you to know these two, because this is what you'll amend, either the constitution or a statute. So don't forget, for constitution, you will say article is a number, a clause is a number, but enclosed number, and then paragraph is a number. I mean, an alphabet, A, B, C, D, and then subparagraph is a Roman number. It might seem very insignificant. I know that, yeah, but kidogo, you'll be told to amend paragraph A, and then you'll start amending a subparagraph because you have no idea what a paragraph is. Yeah. So very quickly, let's amend now. So have we understood the nomenclature? You say, okay, it's not hard, so there's no point of asking. I know you've understood. So if you want to amend the constitution, you'll amend using a constitutional amendment bill. For example, the recent one, which was your Supreme Court said it was not properly done, it was thrown out. What you used to refer to as BBI. So it was a constitutional amendment bill, purportedly with an intention to amend some articles in the Constitution. Yeah. And then if you want to amend an existing act of parliament or a statute, you'll amend through an amendment bill, like maybe law of succession amendment bill, the statute amendment bill, the name of the statute, and then you'll say it's an amendment bill. Now, the language of amendment will be different depending on what you're amending. If you're amending an article, and I hope you remember what an article is, or a clause in a constitution, you'll amend by repealing or repealing and replacing. So you do not say you've deleted an article. Neither will you be found to be saying, oh, we have substituted an article. An article or a clause, you're either repealing it or you're repealing and replacing. And you can't use any other language. Okay, so for articles, you repeal or you repeal and replace. You repeal and replace if you're replacing that particular article or clause with something else. For sections of a statute or clauses in a bill, for our purposes, a section in a statute, you'll equally repeal or repeal and replace. That's the language. You'll see how it pans out. And then for subsections, for your subsections in an act of parliament, you either delete or you delete and insert. You delete or you delete and insert. That's the language. So you cannot repeal a section, a subsection. You can't say we have repealed a subsection. You're either, the language you use when amending a subsection is either delete or delete and insert. And then for a paragraph in either the Constitution or the statute, you either delete or delete and insert, the same language that you would use for a subsection. And then for sub-paragraphs, you either delete, you insert, or you substitute therefore. And you see how therefore is written. There is no E at the end. So don't write therefore like therefore it is as follows. Therefore is without an E. That's how it is written. That's the language of amendment. Substitute therefore. And not thereof, it is therefore without an E at the end. So that's how you will deal with a subparagraph. You either delete, you insert, or you substitute therefore. And then for words and expressions, let's say the word a child, that's a word. A word or an expression in a statute or a constitution, you're either going to delete, insert, or substitute therefore. And you can see how therefore is written. If you're not normal, therefore it's not your ordinary, therefore it is therefore like how it's written here by Senior Dima. Okay. So have we understood the language of amendment? Because if you don't understand that language, you can't amend. You can't amend. So first of all, you understand the language. But I can actually give you a quick minute to write it down. Cindy, write it down. Write it down. You can write it down.
Please just share it in the group as well, and then we can just also move.
Right now, I don't know how to multitask. Maybe someone who has it can send. It's on the group. It is. You can scroll down and up to a document saved as guest lecturer presentation. It's amongst the document I shared. But of course, most of you guys might be having it, especially if you've been in this class before. So please share this document in the group, or you could take a screenshot of the language. It's important for our consequent discussions. Okay, so there is no understanding here. There's nothing to understand. It's just remembering it's what to do for each of the nomenclature, Maybe it would have been important to discuss what amendment is, the definition of the word amend. Yeah, it is defined under Section 2 of the Interpretation and General Provisions Act. Amend means repealing, revoking, rescinding, cancelling, replacing, adding, varying, or doing anything of these things simultaneously in a written law. So you can amend by deleting, you can amend by repealing, replacing, substituting, therefore. Okay, but most important is this particular list. You have to remember how to deal with each of those particular sections or paragraphs. Okay, should we amend now? If you understand the language, you can easily amend anything. So easily. Okay. Okay, so let's amend. Maybe we could start by this example. We are required to amend the Constitution to provide for equal sharing of revenue raised nationally between national and county governments. Okay, so that's what we are amending. So let's go to that particular article that provides for equal sharing of revenue raised nationally between the national and county governments. So it is Article 202. It provides revenue raised nationally shall be shared equitably among the national and county governments. Okay, so after identifying the article, of course, for your purposes, it will be there. It will be pasted there. So we are supposed to amend. So we're supposed to amend that article. Let me just paste it up there, so you can see everything on the same page. Okay. Oh Lord. Oh my God. Okay, yeah, I think I can paste it right here. Just zoom out. Yeah, so this is, it tells us we are required to amend the Constitution in order to provide for equal sharing of revenue raised nationally between the national and county governments. So the status quo, or the article that provides for that, reads, so it's Article 202, Clause 1. It's so hard for you to say a clause because we are all used. Personally, I say articles, sub-articles every day. So it provides that revenue raised nationally shall be shared equitably among the national and county governments. So we are required to amend this particular article to read that revenue raised nationally shall be shared equally between the national and county governments. Now, you identify what exactly is being affected, like what is changing in our statute. So you will easily identify that what is changing is equitably. our article provides that revenue is going to be shared equitably, but we don't want equitably, we want equal. You know, equitably means we are going to take considerations of, historically, whether you've been disadvantaged, and therefore we are going to give you more. We are going to take into consideration the population, or of that particular county before we allocate. We are going to look at maybe geographical location, the advantages that you have over other counties, and then we allocate. This is what equitable means. Like, we consider like where you're coming from. And then equal means we really don't care. All of you get same share. So we want to delete equitable and replace that with equal. That's what you want to amend. Okay, so this is how you would draft. So the question will read just like this, and then you ask to amend. Yeah. So you will be asked to amend this particular article to provide for equal sharing of revenue raised nationally between the national and county government. So this is how you would draft you can't just amend, you have to draft an amendment bill. An amendment bill doesn't have arrangement of clauses. You remember that part for short title, interpretation, part 2, establishment of a body. You do not have that particular arrangement of clauses in your amendment bill. So your amendment bill, for example, what you are amending, you will have a title, like you'll write here, the Constitution, Kenya Amendment Bill 2021. So it has to have the title. And titles for amendment bills are like as easy as that. You see, if it's the Law of Succession Act, you say the Law of Succession Amendment Bill 2021, the year that you're preparing this bill. So the Constitution of Kenya Amendment Bill 2021. And then, of course, you remember our long title, a bill for. Do you remember? So instead of starting with your arrangement of clauses, you start with page 2 of the bill. So a bill for an act of parliament to amend the constitution, full stop. Because this particular bill is for that singular purpose, amend the constitution, nothing else. And then of course you have to have your enacting formula here. It is enacted by the Parliament of Kenya as follows. So you remember that part, so I'm not going to belabor the point because you've seen it before. But your title is amendment bill. So you will have your clauses, and remember, short marginal notes have to be there. So you draw the usual line, and then you say clause number 1. Clause number 1 is your short title. You remember, just like the other clause 1 in a normal bill, short title. This act may be cited as the Constitution of Kenya Amendment Act of 2022 and shall come into force 1st day of July 2022. You could have that. And then you put over here, Lord, it doesn't have, but a marginal note like short title, because it's a legislative instrument, needs to have a short title on the side. Like the named short title, a marginal note, and then you go to your clause 2. Now, this is where it's at. So your clause 2, the rest is very easy. Like saying a long title, putting your title, long title, short title is super easy. So clause 2, you start using the language of amending. So what you are amending, remember, was removing the word equitably and replacing it. Okay, I'm using replacing very, very mildly, replacing it with the word equally. We don't want equitable, we want equal. So you will say Article 202 of the Constitution is amended by deleting the word equitably appearing in clause 1. Do not make the mistake of saying appearing in sabbatical 1. Sabbatical, you're achana nayo. So appearing in clause, you call them clauses and not sub-articles. So appearing in clause 1. So you have to tell us specifically this particular word that you're amending, where is it to be found? So it is found in clause 1 of Article 202. And substituting, therefore, the word equally now. You see, we are using speech marks. Okay, I think these things are not called speech marks. Highly suspect. So you will say, you open, They have another name, like a more, they're called
Quotation marks.
Quotation mark.
Opening
know,
quotation marks.
English teacher told me speech marks, Bana. I was misled, but thank you. So I'll be calling them opening quotation marks. Sounds very, very clever. So opening
Yeah.
quotation marks. you okay, just wait a minute before you ask a question. Sindio, just 1 minute. Kidogo tu. Nimalize kucontextualize hii and then tuulize maswali. So you might be asking yourself, it's an article. Why are we deleting and substituting therefore, and you're not saying repeal? I guess. So I'll tell you why shortly. That's how you couch it. You say you have amended Article 202 of the Constitution by deleting the word equitably appearing in clause 1 and substituting therefore the word equally. Now, the reason why we are using the word deleting and substituting therefore is because what we are amending is a word. We are dealing with a phrase and or a word. If you go up to our language of amendment, we said that anytime you're dealing with words and expressions, you're going to delete, insert, or substitute therefore. So what we have done in our Article 202, we have deleted the word because we are not amending Article 202 entirely. We are not, there is no overhaul of 202. We're just deleting a word in Article 202. So when you're dealing with words, you either delete, you insert, or you substitute therefore a word. So what we've done is we've deleted the word equitably on Article 202 and substituted therefore with the word equally. Therefore, if amended, now like just let's say textual amendment, it will read, revenue raised nationally shall be shared equally. So basically, our intent for amendment was to say that revenue will be shared equally and not equitably. So what you're dealing with is a single word and not the entire article. Assuming that the question read, amend article, like delete, we are not desirous of having 202 entirely in the face of our statute. We want it gone. We want to wipe it off like the face of our constitution. We don't want 202. You will say that Article 202 is repealed. So you're not saying repealing because you're not entirely doing away with Article 202. You're just dealing with a word, like rather you're deleting a word on Article 202. So that's the language that you would use. Maybe you can do one more example. You can go through one more example. And then you guys will ask a question. Okay, so let's assume example 2. Let's remove the color. We can use new colors. So example 2, you're required to amend the constitution to provide that all revenue raised in the country will be shared equally between the national and county governments. This is what we've done. There is another example. Yeah. There has to be another one. It's that example. Sorry. It's this example. We have done a different example. This is an entirely different example, albeit from the same article. So Article 202(1) provides that revenue raised nationally shall be shared equitably among the national and county governments. But now we want to say all revenue that has been raised in the country, both county level, national, will be shared equally among the national and county governments. So you start by asking yourself, what are you amending? Are you amending a clause? Are you amending an article? Are you amending a paragraph? Are you amending as a paragraph? Are you just removing a word? That's where you start. So after you figure out, you now amend. You put the title Constitution, the Constitution of Kenya Amendment Bill, the year, and then the long title, a bill for an act of parliament to amend the Constitution, clause 1. This act may be cited as the Constitution of Kenya Amendment Act 2021, and then you start amending. So if you go back to our Article 202,
we are just dealing with words and phrases. This article will remain this article will remain as it is, 202. But now it will read differently. So you say Article 202 of the Constitution is amended in clause 1 by inserting the word "and from the counties." You could say by inserting the word or inserting the expression "and from the counties" immediately after the word "nationally." So if you go up and check where the word "nationally" is, we've said, and inserting the word, it's amended by inserting the word "and from the counties." So we would, let's just do it, and from. So you say that is what the first thing we are doing. We are amending clause 2021 by adding the expression "and from the counties" immediately after the word "nationally." And number B, deleting the word "equitably," appearing immediately after the word "shared," and substituting, therefore, the word "equally." So we are going to delete the word "equitably" and replace the word "equitably" with the word "equally." So our new article will read, "Revenue raised nationally and from the counties shall be shared equally among the national and the county governments." That will be the amended article. I'm not sure whether you have any questions. You know, it's just playing with those words, inserting and deleting, substituting, therefore playing with those terms. But remember, where you're dealing with an article or a clause, then the language will be slightly different. You'll be repealing and replacing, especially where you're doing like an entire overhaul of an article or an act. Okay. Do you have any question? Oh my God, it is 9:40.
Do we sign after?
You're muted.
Surely. Mnanimute aje mapema? Come on, mmechoka. Yeah, I was telling you guys, yeah, you could sign or you could leave it without a signature. It's not injurious if you forget to sign, as long as you've used the correct language of amendment. Si ni hivyo sasa. Do you have any questions regarding amendment?
Yes, the
Yeah?
marginal note in the amendment. What
Yeah?
do you say? The marginal
If
note in the amendment.
For example, over here, so there will be a line, and then this is still called a short title. Over here, it's still called a short title. And then if your let me show you how you put it. Let me show you from an exact amendment bill, like a proper, that's like an example. Let me show you from your law of succession amendment bill, which I know that you have access to. It has those marginal notes, how you put them. But let me just show you before we go to the next thing. Mwache kuni mute. Mnajua mtani miss next week. Ni sawa tu. Ama mtani miss. Mtu alikuwa ameni mute. Nitampata. I know you're tired. But it's understandable. Lakini tuko karibu hata kumaliza. Unajua, bill is the most lengthy thing. As long as you understand a bill, you're a conqueror. Like you can do everything else. Yeah? But it's all about a format. You get, if you can draft a table of, what we've called arrangement of clauses in a bill, that you're unshakable. You're unmovable. There's nothing that can shake you, can move you that paper, because, let me show you. Just give me 1 minute. I was trying to get it from Kenya Law. I think I had not downloaded, from your National Assembly website. So let me show you how you will put your your marginal. So it will be like this over here. It doesn't have arrangement of clauses, like none. Sawa. So you write your title. So it's if it's an act of parliament, maybe law of succession, it will be a law of succession. Amendment is enclosed. Bill, 2020, a bill 4, this is what you call a long title, and then you put your enacting formula. Still, it's actually a bill, but now it's an amendment bill. So it's a short, draw a line. There's no line over here, but you will draw a line. This act may be cited as the Law of Succession Act 2020. Alafu short title on your, it's still called a short title. Yeah, and then you will go to whatever you're amending. For example, over here on the side, it will be amendment of section 3 of the Principal Act of Cap 160. Yeah, you will say amendment of section 29 of Cap 160. Deletion of section 32. You can just say amendment. Don't, you know, can amend by deleting. You just say amendment of section 32, or deletion, by the way, because you're removing it. Amendment, that's how it would look like. That's how your nini would look like. Your marginal notes for an amendment bill equally has a memorandum of object and reasons, or bills should have. And then this one is has the date here, and the Abijiro Alake, a senator, was the sponsor of this particular bill. But anyway, that's how you will do your marginal notes for a bill. You'll be saying amendment of section 3, amendment of section 29, and then you're inserting where you're dealing with maybe words or phrases. We said you can, it's allowable for you to say you're inserting, that's the language. You can say you're substituting. Therefore, you know, you're deleting and substituting. Therefore, what is happening? Yeah, you can go through this bill or any other bill. See the language that is being used and how to put your, and remember this therefore is not like with an E. I know you might forget and write E at the end. Okay, so do you have any questions regarding amendment? Okay, sawa. As long as you can remember that language of amendment. Kama ni kukram ni sawa. As long as you remember.
Lydia, one more thing.
Yeah.
So in the example that you have done, it will read amendment of Article 202 of the Constitution of Kenya.
Yeah, you will write amendment of Article 202 of the Constitution of Kenya. Look at the BBI one, how they were couching it. You know, we already have a bill for amendment of the Constitution. So you can just actually search on the Google, just write Constitutional Amendment Bill. It will show up, see how they were couching it. And equally, you can share it on the group. You can download the PDF, share with us on the group. I might show you. Oh my God. Let me show you. But now, whatever you see, don't take it too seriously. The marginal notes are on the left-hand side. This so, oh my God. This so, how you'll struggle writing on your, unless you're left-handed. So this is the BB, everyone calls it the BBI, the Constitution of Kenya Amendment Bill 2020. So you'll say short title, insertion of a new article. If you're inserting a new article, of course, you're inserting a new article. You're not amending any article. So it's insertion of new article 10A. There is insertion of another new article there. There is amendment of Article 82 of the Constitution. But just put your marginal note on the right hand. This looks so it's like my eyes can't even see clearly. There's just something about it. Yeah. So you put it on the right hand side. So amendment of Article 82, that's how you would ideally put it. This thing was that lengthy. No, I've never even read it. But it's so lengthy. Oh Lord, it's actually 44 pages. It has a memorandum of objects and reasons. Yeah, so that's how you will put it. Just look at the BBI one. I mean, the Constitution of Kenya Amendment Bill 2020. Okay, so should we go to the next document? Let's first of all go back. We see how much we've done. But everything else, Ebu, let me know whether everybody can draft a bill. If you cannot, I am here for you. Just tell me to repeat. But you might tell me to repeat and then someone will mute me. Okay, so demand letter, let's highlight. Yes.
Could you kindly share the short bill that you had in the group? The bill that you projected.
Yeah, the Nuclear Atomic Commission bill.
Yes, please.
Yeah, I'll share all these documents like ASAP immediately. I can't use my phone and still do something else. I'll see so many texts. I want to look at them from your colleagues. So we have done a demand letter. Don't forget the format of a demand letter. You start with, of course, the details of the sender, the details of the recipient, and then it has our your it has the date, and then it has the recipient, and then it has the salutation, like basically contents of a letter. And then it has and then it has that introductory paragraph, you know, the above matter refers, we've been retained or we've been instructed by Ms. AY's user client to address you as follows. And then it has factual basis. After your factual basis, it has the legal support paragraph. And then it has a conclusion. In your conclusion, we say that we are going to make a demand. After making the demand, we will tell you the time frame within which to comply, and then we'll tell you consequences of non-compliance. And then we sign off. Is it called signing off? And then after your, yeah, that's it. That's basically content of your demand letter. And then your response to demand letter. I've told you to draft this. Nonetheless, it has an introduction, like the obvious contents of a letter. And then after your introduction, just say what your client wants, whether they admit liability as in the demand letter. Oh Lord, admit liability, deny partly, admit partly. You just tell what your client wants, and then you will have a conclusion. So your conclusion is what your client is going to do. And then you sign off. A legal opinion, we've said you're going to use FIRAC. And then office memorandum, we've said you have a question presented. Oh Lord, let's finish this. And then, you know, I thought you guys might actually do two things. Let's finish and then I'll tell you. Question presented, a brief answer. Sindio. Alafu, factual, like facts, you know, factual basis, background. You can say background sounds more clever. It sounds sophisticated. And then you go to discussion, or what you call basically analysis, and then you go to your conclusion. But remember, an office memo is like an internal communication. It's you and your pupil master, like someone who works there. But it's a form of actually giving an opinion, like it's a form of an opinion. Oh Lord, why would I write conclusion like that? And then conclusion. So let's see what else. Bill. Let's arrange the clauses. We had a preliminary clause section, part one. So this is where we had our short title and our interpretation or definition section. And then we said we will go to our part two, which is establishment of a body. We said we first of all establish, compose it, give it duties, give it powers, and then we go to the other part of our bill. So I'm not going to type that because I think you have it. We go to administration, that part. And then after administration, that's where we have our secretary, the staff to the commission, and then we have miscellaneous, or what you called final. My God, let me just write final provisions. In your final provisions, you just have the financial, like where you'll be getting your money from, and then you have offenses. You have to create an offense, provide a provision for offenses, and then you have regulations like the CS or the commission can make regulations in order to, meet the objectives as under the act. Amendment bill, you have to, most important thing is remember the nomenclature. Don't call a clause a sub-article, and know how to deal with each. Know how to deal with a word, to deal with a phrase. So nomenclature, and remember language of amendment. Yeah, so you're substituting therefore. Okay. Let me see. Let's do away with these. Let's do one of these and then one of these. We do statutory. Let's start with the regulations since we are discussing bills. Sindio. So in that same breath, let's discuss regulations. So let me get some regulations for you. I know you've seen so many regulations, like they're all over the place. There are so many, including the latest one, Section of Properties Regulations of 2021. So let me get our regulations for purposes of our exam. And we will have it. Just give me 1 minute. I get it for you. 1 quick minute. I'm sorry. I didn't download that paper. I forgot. So just give me, let me show you where to get those papers. Let me just show you even for your subsequent. So you would go to CLE's website, okay? And then you go here, downloads, the first thing written, downloads, yeah? So you say downloads, of course it will open downloads for you. And then can you see my screen? There's some papers here. March 2023, you can see. There is October 2022. Can you guys see? No?
Yes.
Can.
Ziko hapa. Kuna, like they are there, you download whichever you want. So specifically, I'm looking for, this is what I'm looking for. You can see, yeah? Can you guys see?
Yes.
Guys, okay, sawa. So let me show you a regular, oh Lord. I got civil instead of LWD. I know you guys never want you don't want to see things which you have done. You want to encounter them January in your pupillage. Okay, so regulations, the question will just ask you draft regulations, just like that. You know, we've said that the bill can empower a cabinet secretary, a commission, a ministry to actually come up with regulations. So regulations, they are simpler than a bill. They're like more straightforward than a bill. Even the content is less as compared to a bill. So your regulation, it will have a, can you guys see? Oh, let me stop sharing and then I share again. I'm reading whether you get, I thought so. Oh my God.
Ulichomoka.
Sasa mbona mnani mute surely? Nimwambia mtanitafuta kama Yesu. Hamtanipata, nyinyi ni mute tu. So it has so a question on regulations will be draft regulations, just like that. It won't be a trick question. LWD questions are straightforward. Draft a demand letter, oh Lord, we have to discuss a deed poll. So you have to pick pace. So because we drafted a bill, this will be so easy for us. Remember, any legislative instrument has to have marginal notes, all of them, including regulations. So there has to be a marginal note. So you draw our line on the right-hand side. Sawa. Halafu, after drawing your line with a ruler, it has to have a title. Let me show you the question that we are drafting. Just a minute. Let's go up to question 5. Mko na mchezo sana nyinyi. Ati mnani mute. Kweli. So hii swali inasema the cabinet secretary is the Ministry of Finance of country of Poland, who has instructed your firm to prepare regulations for payment of fees for registration and licensing of fishmongers. Prepare a draft of these regulations. The draft should not consist more than 5 regulations. Note section 2 of the Fisheries Act defines the cabinet secretary as the cabinet secretary responsible for matters relating to fisheries. Section 16 of the Fisheries, we have a Fisheries Act. Please mute, guys. I know you're tired, but just mute. We're almost done. Section 16 of the Fisheries Act provides that the Fisheries Authority may impose a levy in Adiara. Section 3.4 The Fisheries Act provides the Cabinet Secretary in consultation with the CS in matters relating to finance may make regulations for better enforcement of the duties thereto. So we scroll down to our answer. Let's see, first of all, what these guys scored. Question 5, they got a 7. So let's see what they did wrong. Of course, we'll be able to see what they didn't do. Because a 7 means they missed 3 all marks. Okay, nonetheless, this is the format of drafting regulations. Your regulation, I have some regulations, but they're quite lengthy, so I wanted to use these ones. Yeah, so you will start with the name, I mean the title of your regulations. These are the Fisheries Regulations, 2021. And then you could, not necessary, but you could tell us what, like where you see, for you to make regulations, you have to be empowered by a statute. For example, section 34 of the Fisheries Act. And then our regulations, you could briefly tell us the content of the regulations. Yeah, you have the citation, you have the interpretation, the prescribed fees, and the offenses. That's all, because the question asks you not to have more than 5 clauses. Five regulations, I think 5. So you remember what was in our, how we were doing our bill? It's like that same concept, but now your regulations are kidogo. It's not as comprehensive as a bill. And then it's like regulations are usually procedural law. And then you repeat you write your title again, like you are doing in a bill. The Fisheries Regulations 2021. And then you start with your citation. The citation is like a short title. You remember what you call a short title? Yeah, that's a citation for purposes of regulations. You call it a citation. So you say these regulations may be cited as. You remember in our bill, we were saying this act may be cited as. So these regulations may be cited as the Fisheries Regulations 2021. And then you have your interpretation section here. The act means cabinet, the usual rules, yeah? Prescribed fee means a person applying for means, and then you say a person who wishes to, you go to your clause 3. Clause 3 particularly provides for prescribed fees, because I think it's a requirement in the question. So you say a person applying for registration as a fishmonger under the act shall pay. Because regulations are used for procedures. For example, provide for a fee payable, equally provide for, what else has this guy done? They've created some offenses, yeah? A person who fails to pay prescribed fees, this is what you are going to do to them. Yeah. So those are regulations for you, but these regulations, they seem incomplete. I'm not sure whether you guys can see. If you go to the question, it required something very particular. Let me just see. Oh Lord. And look at question 5. I think the reason why they got a 7 is because one important clause missed. They got 1 mark on the title, and then they got, let's see, they got 1 mark on the title, they got another mark on the citation, they got 1 mark on the definition. Probably there's something they didn't define. They got 2 marks for prescribed fees, they got 2 marks for offenses, 4, 5, 6, 7. Yeah. I'm not sure what they missed, but probably a clause that the examiner was looking for. But be that as it may, that's the format of your regulations. Okay, so I'm going to share this paper with you, so don't worry. Okay. Okay, so regulations, I'm going to share that paper with you. You look at it. So let's draft instructions now. What Evans was asking. Let's draft instructions. So we are going to explain what instructions are, first of all. Just assume you're a member of parliament. You know, there was a time, I'll tell you the story someday, but assume your member of parliament is your very good friend. Or maybe not even your friend. Maybe he knows you, yeah? And he's in need of he's in need of instructions, or rather, he's not in need of instructions, he's in need of a bill. Yeah, he wants to introduce a bill at Parliament because, you know, maybe he wants to bring back maziwa ya Moi. He wants all school-going children to get free milk, free lunch, you know. So that is what he wants. So he approaches you for your first meeting. You see, you're unable to comprehend exactly what you want unless he put it down in writing. So that is what we call legislative instructions or drafting instructions. These are basically instructions given to you by someone who's in need of a legislative instrument. So I will give you instructions for purposes of enabling you to draft a bill intended for that purpose of making sure food is available for free to our school-going children. So legislative instructions are basically instructions to that extent. They are meant to enable a drafter understand what a proposed bill intends to achieve or what a particular maybe legislator wants in their bill. You know, that those are legislative instructions. Let me just give me a minute. I show you something. Maybe it will help you contextualize. It has some theoretical basis on legislative instructions or drafting instructions. So this particular, let me just control find. Let's just write the word instructions. Oh my God, these results. Oh, here. So it's on page. It's on page 49. Page 49, you know, tells you what drafting instructions are. Says before embarking on a drafting assignment, a drafter must be clear on the mischief or defect intended to be remedied or the opportunity to be embraced. So a drafter has to appreciate in detail the task ahead, and this can only be possible if the drafter is afforded proper drafting instructions. So these are instructions given to you. Maybe you work at the parliament, yeah? So they're given to you by a member of parliament, Nyamira, and they tell you what they want to achieve by a bill, you know, so you draft for them because, you know, they are maybe an lawyer. Okay, they're an lawyer, they might be an advocate, but it's not their duty to draft any bills or any regulations. So they give the work to you. But as they're giving the work to you, it has to come with instructions, like written instructions on exactly what to write in your bill, exactly what to go into your regulations. Okay, so that is what it means. And you have to work with the instructing department. You can be instructed by a ministry, yeah, to draft a bill. You can be instructed by a legislator. You can be instructed by a body to draft to draft a particular bill, to draft a particular any legislative instrument for that purpose. So those are drafting instructions, or what you would call legislative instructions. They are meant to enable a drafter know exactly what is meant to be achieved through the instrument. Is that clear? So some of the content of your drafting instructions, before we look at one, include the general factual information on the current framework, like the status quo. For example, you would say our current Children's Act is not big on adoption, or rather, it doesn't have procedural provisions on adoption and the nuances there too. Okay, like you highlight the status quo. After highlighting the status quo, you proceed and highlight why there is a need for change. You know, so tell us maybe our law is silent on maybe surrogacy. Wait, there was a bill on surrogacy. Not sure whether it was assented to. The last time I checked, it was that committee stage. Yeah, the committee stage. That was second reading. So you tell us exactly what you want to cure by your bill. You know, a legislative instrument is meant to cure a problem. So you tell us, okay, Sawa. So why do we need this bill? What is it for? Do we need it in the first place? Or, you know, this country has so many, Lord, if you go to Kenya law, you'll be surprised by the number of statutes that we have. Like laws are being enacted on a daily basis. So the question is really, do we need this law? What is it meant for? Or maybe we just need a simple policy, which can actually be a means to an end, instead of like an entire rigorous process of drafting a bill, presenting it at the parliament, first reading, second reading, committee stage. So can it be remedied by any other thing? Like you tell us background, you tell us what you need to achieve by this bill of yours. So this particular guy who will be drafting knows exactly what to write for you. not for you, but what to go into your into the bill. So it has the aim of the proposed legislation in detail. Equally, comment on possible scenarios for achievement of these aims. So it could suggest maybe we need a particular authority. Equally, there might be need for funding to this particular authority to enable it carry out its functions. It could have information on timescale or how exactly to work. Maybe by the first week. Oh Lord, please mute. Oh my Lord. Eh.
Someone
Okay,
is really
yeah.
misbehaving there. Monty John.
Who is it? We remove them. Yeah, please mute, please mute, please mute. We are almost done. So time scale is the time, like the duration. Maybe they have the first 2 weeks to submit a draft, which will then be, you know, reviewed and then recommendations made. You submit your second draft in the second month, and then lastly the final draft. Okay, so time scale is as a drafter, do you have any how am I going to work in terms of time? So you can look at this page, by the way. I am not going to belabor the point, yeah, but it's all here, like the theoretical bit of a legislative instruction. A legislative plan is basically, it has the outline of, it will be contained in the instructions. So let me show you drafting instructions, how they look like. I mean, the format they will take, because drafting, I understand, is the most critical thing for you. So let me check drafting instructions. Just one quick minute. I get it, and then I project it. All right, over here. So it has, it should have a letterhead. It has a It has a letterhead. The letterhead is that of a particular ministry, because these are instructions from a ministry. You can get instructions from a drafter from anyone. Yeah. So these are instructions from the Ministry of Trade. I think right now your favorite Moses Kuria sits as the CS. And then that's the letterhead basically of the ministry, and then has our ref, a letter. It's a letter. So the letter is addressed to you. If you don't know the name, it's addressed to the Office of the Attorney General. Well, it could be addressed to a particular drafter. Yeah. Equally, this is not a good letter. You know, you can't send a letter to the Office of the AG. You are addressing it either to the Attorney General himself, or maybe a particular state council, but you can't send this to the Office of the AG. What is that? So you can say the Attorney General, but you can't say the office. An office doesn't have hands. Like, come on. So the Attorney General, and then dear sir, madam. Of course, we know the Attorney General is a sir. Come on, it's common knowledge. So drafting could be, now your recipient could be any drafter. Doesn't have to be the AG. Okay, but now because the AG is the legal advisor of the government, the ministry is sending the instructions to the AG. Maybe the ministry has seen a particular omission, a particular something that needs to be remedied using an act of parliament or some legislative instructions. So it's sent to the AG and then but remember, legislative instructions can be sent to any drafter. It can be sent to a state council. It can be sent to the principal, you know, our guy. Yeah, the senior that we call Dima. It can be sent to Dima, and then, you know, Dima as the principal legal advisor council, National Assembly, then they will be able to maybe delegate the work. But basically, instructions can be sent to anybody. Yeah, not specifically the Office of the AG. It can be sent to anybody, any drafter. And then the is drafting instructions for a franchise bill. That was the intention of this particular drafting instructions. We've said you can call them legislative instructions, but now these instructions are sent to for purposes of a franchise bill. There is need for a franchise bill. So they say we refer to the above matter. We have sought to provide you with all the information you may require. Oh Lord, you can't say we hereby, but this sounds so wrong in terms of syntax. We have sought to. Huyu ni kama alienda huko kwa shule Kashpur Kabondo. But it's not, okay, I don't know what you think, but I feel like in terms of syntax, it's not, there's a problem. Nonetheless, something along those lines, you can't write the same thing, all of you. So you're basically telling them that we forthwith provide you with information that you will require in drafting such legislation as, oh Lord, no. There's something absolutely wrong with that sentence, and I'm not sure what it is. I'll share with you some other drafting instructions. Pick the most, you're not cramming, Cindy. Let me show you something that you will say instead of that language over there. Honestly, I don't have anything better to say. I'm trying to think. I'm trying to copy paste from another drafting instructions, but something along those lines that we hereby, don't say we hereby, like maybe a synonym to hereby, provide you with the following instructions that you may require in drafting the legislation. And then you proceed and say, number one, proposed registration. The proposed legislation is the franchise bill. Do you think there is a problem with saying is the franchise bill? The sponsoring ministry is this department, department contact, date of cabinet approval. There has to be a cabinet approval attached to your instructions, especially where you're receiving them from the ministry. Yeah, there has to be a cabinet approval for formulation of the bill. So a CS can't just send instructions. The cabinet has to have approved sending out such instructions, and the formulation of the bill has to be actually approved. So this is the most important. After that, this is the background of the instructor, the instructing ministry, or the instructing person. So you go to this is the most important bit of your instructions. General background information. This is basically the status quo, like what's happening now, in franchising, this is what's happening in this country. It's a strategy for business growth. Currently, there is a number of producers, but now you know what? We don't regulate franchises in Kenya. We only have statutes which are incidental to particular aspects of franchise, but we don't have any statute that regulates franchises. So you could actually, after telling us the status quo, you specifically tell us the existing laws, like laws which, even if moderately, govern franchising. So Kenya doesn't have a single law that regulates franchising activities. So there are different statutes which govern different aspects. You name those aspects, and then you proceed to, if you can remember, you don't need this. If you can't remember, it's how. But you have to tell us the laws that the existing law, because it's what you want to remedy. If there is a law already, you're either amending it. You can't come up with a new law, whereas there is an entire Law of Succession Act. Unless you do an entire overhaul to the act, you amend by repealing that entire act, and then you bring a new act. So you could tell us existing laws, and then you go to comparative analysis. Well, if you have time, but it's not an important part of your legislative instructions or your drafting instructions, nonetheless, you could put it there to seem clever. I believe you won't even remember this, so just ignore. So you go to main, okay, let me just put it back in case you want to put it. So you go to the other part, equally important, main objectives of the bill. This is super, super important for any legislative instructions. You tell us what are the objectives of the bill. You number them. You tell us, like, I can't tell you what it will be, but just tell us the objectives of the bill. It might be in the question. And then practical implications, or maybe this is what you would call, quote unquote, enforcement, of the proposed bill. You could equally call it practical implications. You can give it any other subtitle, but basically goes to show the bodies that you might need for purposes of enforcement of the provisions of the bill. So you could call it enforcement of the proposed bill, practical implications. The proposed bill will require creation of the Office of the Registrar of Franchises. It will require formation of the Kenya Franchise Advisory Board. It will equally require some consolidated funds for purposes of implementing the proposed bill. And then you could equally discuss unresolved issues. There might be some gray areas in law that your bill might not even address. For example, the issue of tax regime. What taxes will be subjected to foreign franchisors? Like a franchisor, let's say a a KFC, which sells to a franchisee in Kenya, are we going to tax such a franchisor which is not even situated in this country? You know, you could discuss regulations and registration requirements for franchises. What do we need? The compliance requirements. You could discuss the operational standards that might be imposed. You could discuss ethical standards. You could discuss legal advice received. This is what you have garnered so far as the instructing body. Like drafter would need this information for purposes of they could incorporate these advices or disregard them. If they're important pieces of advices, they could follow up on them, see whether it's actually, they can incorporate it on the bill. And then it could have a level of penalties, if any, like what is the recommended, remember that penal clause? What's the recommended penalties, maybe between 5 million. A drafter will know you want 5 million to 10 million as the offense. I mean, as the penalty for an offense under the Act. You could have transitional saving provisions. They will tell you they are not transitional agreements. Because first of all, we don't even have any agreement, I mean, any statute. So there's nothing we are transiting from. Yeah, actually, it was unnecessary to have this. I don't know why they have it. And then proposed commencement date, it will come into operation. You could state there other departments consulted. You could put there proposed timetable. We said it's an important part of your registrative instructions. You need the other guy to know like how much time do they have. And then like how much time do they have for purposes of finishing up with their work. The date of the receipt was 20th October, deadline of presentation of the first draft, and then they will consult. And then after consultation, you amend and incorporate any suggestions on the bill, and then you table the bill will be tabled before the parliament and legislative process, and then ultimately it is signed over here by Wakili wa Serikali, who's acting for Ministry of Trade. So that's how I'm going to share this document and other legislative instructions, but basically that's how they would look like. It's just a letter sent out to a drafter, informing the drafter like the expectations of the instructing ministry, like what do you want to go into our bill. It could be drafting instructions for regulations. Drafting instructions could be for any, including a policy. Yeah, they could be for any instrument, any legislative instrument. So do we have a question on drafting instructions or legislative instructions? Okay. So I want us to discuss a policy. I'm just going to give you part of a policy. A policy is meant for majorly procedures. Yeah. So we could use, usually we use the LSK, that LSK policy on sexual harassment. So of importance, the only part for policy is the policy formulation process. You have to remember policy formulation process. Yeah. So let me get a policy, a copy of a document, like a policy document. Okay. So don't forget to look at policy formulation process. Okay. So usually a policy will have like a title, like a name. Okay. So you can pick a general area. Let's say a mining policy. A minute. Let me see whether that is the policy oh Lord. That's not the policy I'm looking for. Oh God. Do you guys have that policy for LSK? Okay, I shared with you some time back, but you could use another policy. That LSK policy is nice. It has all the content, but you could use another policy nonetheless. Just a minute. I'm going to project the policy shortly. Oh Lord, I don't like this policy. I think I have to get the one for LSK. Okay, good. Guys, you don't have LSK policy. I've sent it to the group so many times. I can't find it. Oh Lord. I cannot find it. I cannot find it. Okay, let me check it from my Google Drive. It's on my Google Drive. Hmm? Oh Lord. Oh my God, I'm so sorry. But then we have to finish the class now. But before we do, let me see whether we have to discuss a case brief before I'm going to give you formats. Can you guys find LSK? I can't seem to find it, especially if I have shared with you the
Lydia.
Yes.
Lydia.
Someone shared it on the group.
Oh, sawa. Let me check. Thank you. That is what I'm trying to look for, but I can't find it. Thank you so much. I'm not sure that they removed it online. It used to be online. I can't find it. So remember to look at policy formulation process because you might not be able to look at it together. So, oh Lord, it's not opening. Oh my God. Can you please send it to my thatbarrevisions@gmail.com? I would really, really appreciate. So send it there as we look at a case brief. So at least by the time we're almost done, we look at a policy. Send it to the email, please. Thank you. Okay, so let me get a case brief. We'll discuss a case brief as we wait for a policy to be shared. We discuss a case brief. So let me get a case brief. At least for a case brief, I know where to very quickly get it. Okay, so let me share. I'm not sure whether you will draft a research outline. There's a document called let me share a research outline as we go to let me project. You know, a research outline. So by the way, once someone sends it to the group, I mean to my email, just let me know. So a research outline is like an outline for purposes of your research. It's not in the course outline, but it has been in so many project works. Yeah. So a research outline looks like a research outline is basically for purposes of your research. Like you know exactly what you're looking out for. So a research outline has a title, and then it says use FIRAC. Okay, so if you're drafting a research outline, you're using FIRAC, just factual background, issues, rule of law, analysis of the rule of law, and then conclusion. If you're drafting a research outline, but it's not on the course outline, however, it's been tested in so many project works before. So a case brief, of course, a case brief has the title, case brief, okay? And then it has the citation here, like it has the names of the parties. Okay, a case brief is a summary of a case. Like you will do a case brief for purposes of capturing like those very important aspects of a case. So if you a judgment, so if you have a judgment, you will do a case brief, and a case brief basically enables you to understand the court's opinion because it's you have to do like very careful purposive reading, and then you're able to come up with arguments maybe against the judgment or maybe for the judgment. So it's basically how would you define a case? It's a summary of it's a concise written summary of basic components of a court's judgment. Yeah, that's a case brief. And I think you guys might draft a case brief. Actually, I think if it's not a legal opinion as your question one, it's a case brief. So a case brief has the citation, case number, date of the decision, quorum, court, and court division. And then, now you'll pick this from the judgment. There's no thinking. So if you see I'm not sure that CLE has the resource. You know, case briefs, the problem is you have to be given like a whole judgment. So if you see that paper, that paper is very, it's very bulky. It's a case brief, because a case brief, you'll have to get a judgment on the side to enable you to draft a case brief. So number 8, you have procedural history. I'm going to give you the parts. Cindy, procedural history of a case brief is basically like what happened, events that occurred after the suit was filed. Like who's being sued, by who, is it an appeal, who won, who lost, did we have guys being enjoined as interested parties, did we have interveners, do you have amicus curiae, do you have interested parties? That's procedural history. Like the suit was filed by Dr. Tatu Kamau, a medical doctor. The DPP was enjoined as a third respondent. There was 2 amices, there were 10 interested parties, like basically the parties of the case and who instituted the suit against whom. That's procedural history. That's the first part of your case brief. After your procedural history,
Lydia.
you go to part E.
Lydia.
Yes, please. Yes, please. Go
Are
on.
you projecting? I can't see your screen.
Okay, let me stop projecting and then I project again. Can you see now?
Not yet.
No. Oh Lord.
No.
Probably the only
Can see.
I think the challenge is network.
Screen is
You
on.
know,
Network, it's a network.
yeah, networks. People's networks are buffering. Even mine a lot. I'm actually wondering why it's too stable today. I think the Lord wants you to study. Yeah, so maybe the network. So you after you're able to see, I'll recap for you, or I'll equally share it with you. So we've said a case brief, you start with this is like content of the case. You copy paste from the judgment, no applying your mind. And then you start with procedural history. That's part A of your case brief. And I've told you guys procedural history is basically events that occurred after the suit was filed, like who was being sued by who. Do you have any part? Is this the first case the matter is in court, or maybe it's in an appellate court? Why is it on an appeal? Who is appealing and why? And then you go to part B. That's your substantive history. Your substantive history or your substantive fact. This is basically the historical factual basis or the factual story underlying the parties' dispute. Like it describes what happens before the parties ended up in court. Like, why are we here? For example, Dr. Tatu in this case, she was aggrieved by the provisos of the Prohibition of Female Genital Mutilation Act, or the FGM Act, and she was saying, as an adult woman, you can freely choose to undergo circumcision, under the hand of a trained medical doctor. She also believed FGM is imperialist imposition from foreign culture, and of course now she believed that those particular sections should be declared unconstitutional that prohibit a grown adult woman from FGM. So that's where she's coming from. That's why we are here. So substantive history is, where are you coming from, like your factual background. And then part C of your, so it's procedural facts, number 1. Number 2, substantive facts. Number 3, rule of law. What has, oh Lord. Oh my God. Just a minute. Oh my good God. Sweet Jesus. So you don't rule of law first. I mean, and I was actually wondering. So you, after your substantive history, you go to your issues in that order. Okay. So your issues are the legal questions that the court must answer. So these are in order to resolve the dispute. So these particular issues, you'll see them in the judgment. So issues can either be law-centered, they can be fact-centered. Issues can be issues that were presented by the parties. There could be issues that were formulated by the court. So issues can spread like in the judgment. Sometimes you might not easily find issues. They might be all over the place. They're not like in one place. Maybe the court is all over. The mind is not like compact. So issues are like everywhere. So you might not find issues on a singular paragraph of a judgment. They might be all over. So your issues are basically what the court was addressing. An issue we've said it can be fact-centered, it can be law-centered. Law-centered where the court has to interpret what a particular law means. For example, these were law-centered issues. They could be fact-centered if, for example, they are just factual disputes between the parties. It's a fact which parties disagree upon. So issues are here. They've been listed. So you just say the following issues were listed by the court for determination, and then you list the issues. After your issues, you go to your rule of law. So your rule of law is basically the law that was relied upon by the court. You could start with the Constitution, of course. Oh Lord, God, so sorry. Constitution is the supreme law of the land. So you could start with the Constitution and just say the court noted that the preamble of the Constitution, or you say the court relied on the following articles in reaching its determination. Article 210, you list the articles relied upon by the court, and then the court equally relied on some treaties here. Article 3.5 of the UDHR, equally the court relied on some case laws. You know, rule of law can either be constitution, it can be statute, it can be treaties, it can be conventions, it can be regulations, it can be case laws. So the court equally relied on the following 7 cases when interpreting the constitution. It relied on Leina, Contella, Getairo, all those cases. So your rule of law is just listing what the court relied upon in terms of the law. And then after your rule of law, you go to your holding. So a holding is a court answer to an issue. So assuming you have 3 issues, you'll have 3 holdings. In our case, we have 6 issues. So we will have 6 holdings. So a holding is defined as a court answer to an issue. And the number of holdings is determined or dictated by the number of issues. So if you have 7 issues, you will have 7 holdings. So you'll start with holding A, holding number 1. On this issue, whether Section 2 FGM Act is unconstitutional, the court held that these sections are not unconstitutional. On the second issue, it was held that the board was properly created. On the third issue, the court held that FGM is a harmful cultural practice. On the fourth issue, like you're just addressing all the issues and the answers. So holding is basically a very brief court answer to an issue. After your holding, you go to your rationale. Your rationale or reasoning, it's don't write like both, just choose one. Rationale, or equally called reasoning, is basically a justification of a holding. For example, so you will have equally, if you have 7 issues, you'll have 7 rationales. For example, if the court answered, let's say question 1, issue 1, sorry, you know, the court held that these sections are not unconstitutional. The court is going to justify that answer in its rationale, because you know a court forms an opinion. So a rationale is a court's explanation to justify the holding. And usually rationale is the heart of the case brief. So the court can apply legal principles in order to justify its holding. And equally, a rationale will appear immediately after the rationale. I mean, a rationale will appear immediately after the holding. And the court can use various justifications. The court can use social justification, political justification, legal justification. So any statement that justifies a court's holding is called a rationale. Yeah, or a reasoning. So reasoning are basically justifications as to why we said these sections are not unconstitutional. So the court in this issue used section 107 of the Evidence Act, you know, stated that he who what must prove, he who asserts must prove. Yeah, so the court used that particular section and said, you know, the petitioner had not discharged the burden of proof. And then on issue number B, whether the board was created illegally, the court, Narita Karimi Njeru, said that equally the burden of proof was not dispensed with. And then whether FGM is harmful cultural practice, the court explained that there is no one who would choose to suffer serious health implications, like you wouldn't voluntarily want to suffer. And to support its reasoning, the court placed reliance on Katet Nchoe and said that, harmful cultural practices are in dissonance with human rights and they cannot be allowed. Yeah. So the court ultimately held that FGM is a harmful, it used some social justifications and actually legal justifications as well, to state that it's actually the duty of the state to protect the citizens, including their health. So my point is, a rationale or a reasoning is just like an explanation as to why the court said yes or said no, or answered an issue how it answered. And then the last part, oh Lord, the last part of your case brief is a judgment. That's the last part. A judgment is basically the final, the court's formal action or the final decision. Like now, what next? So it concludes your case brief. So it's the court's final decision. For example, the amended petition was found to be devoid of any merit. It was dismissed. And the AG was ordered to forward proposals to consider amendments of Section 19 of the FGM Act. That is what the court held. And then ultimately, every single party to bear their own costs. Commentary on judgment is another extra element. Well, in your exam, that will be the last part of your case brief judgment. So commentary is just what your opinion, because you're writing a case brief. Do you agree with this particular, judgment or not? Because you just can't accept judgments blindly. You can actually question them, So that's how you'll do your, let me show you an acronym. Do you remember the acronym for police file? Ama you forgot immediately after, but you have to remember it. You can pass it down to your, to other guys who will join that school. Okay, let me show you procedural fact, substantive fact, and then issues, and then rule of law. Let me show you what I use. Well, I'm not sure whether you'll be able to remember. Oh Lord, we have to hang up the call. My God. So these are it looks like: procedural fact, substantive fact, issues, rule of law, holding, rationale, and then finally judgment. And of course, it has to have a title, case brief. So I use this particular acronym. See, it's called I've already forgotten. So that's how I used to remember. Of course, up to this date, I would remember part of a case brief by Peter HRJ. You can use yours. You can come up with an acronym, but if you can remember without an acronym, that is okay. Okay, you don't have to use it. So that's how you would. I remember parts of a case brief. I'm not sure if they have any question.
I have a question.
Yes, please.
What about the dissenting opinions? Do we include those here?
No. Well, they're called extra elements, including your own opinion or an obiter dictum. You don't include a dissenting opinion, especially for exam case briefs. Well, if the question is, depends with the marks. If that judgment has an obiter dicta, it has a dissenting opinion, you will write it as the last thing after the judgment of the majority. And then you'll write their dissenting opinion. Like in one sentence, you will say the dissenting opinion of maybe Justice XYZ was to the extent that, and then you say what they were, how they reasoned, like very briefly. So you don't analyze a dissenting opinion substantively, because a dissenting opinion is not like it's not even binding. It's not even persuasive. It's just like a dissenting opinion is an opinion. So you put it like one last paragraph, even like 2 sentences. You say there was a dissenting opinion of Justice XYZ to this extent, and that's it. Yeah, you could have a dissenting opinion. However, the most important part of your case brief will end at the judgment. Yeah, you could have those extra elements: your opinion, dissenting opinion, obiter dictums. You could have those after you're done with your judgment. You could have those extra elements. Yeah. Okay. Let's go to that list. Oh, I told you did polls. So let's discuss a did poll. Let me get a did poll. So a deed poll is a document that is used to change a name.
Please project it. That will come as a drafting.
Definitely. Let me get a deed poll. Yeah. So a deed poll is used to change a name. I want to get one that has all ninis. You know, a deed poll is a standard form. They're like they have a lot of legalese. A lot of legalese. So deed polls will be like you'll draft a different deed poll depending on who you are. There are different deed polls for different categories of persons. So let's start with this deed poll for an adult. Okay, let me give you the documents that you need for deed polls first. Oh my God, I really hope that this guy. Okay, Sawa, let me get you documents that we need for deed polls, and then we look at a deed polls in your so for deed poll, okay, let me just stop talking. I get it fast because I cannot multitask. Okay, so a deed poll is a document provided for under the Registration of Documents Act. And a deed poll is used to change names. So you read Registration of Documents Act together with Registration of Documents Change of Name Regulations. Okay, so those are the